Hello, good morning, everybody, and welcome to this arbitration, exit arbitration /125 Finley Resources, MWS and price management against the Estados Unidos Mexicanos. As we know each other by now, but to the extent that this is going to be recorded, probably a presentation here is in order. On the part of the tribunal, this is Manuel Conte. I'm a Spanish national. And together with me, we have on my right Franz Stierman. He is both Swiss and Peruvian, and Spanish speaking as well. And then on my left, and he was appointed by the claimants, and Monsieur Alain Pellet, who is a French national, and he was appointed by respondent. Unfortunately, he's not Spanish speaking, and that's why we have been interacting within ourselves, always in English, and
or in French.
Or in French, occasionally in French. And for that reason, I beg Mexico's indulgence, but because I will be speaking mostly in Spanish, in English, except on a few occasions. Before I give you the floor, in case you have questions, for housekeeping purposes, first of all, the tribunal hasn't heard from Mr. Keoseyan, so we take it that he will not be coming to this hearing, neither in person nor through video conferencing. I will later on ask the Mexican representation to confirm that they haven't got either any message or writing from Mr. Keoseyan. Then, as we told you last Friday, to make life easier for stenographers who have a very hard time in these hearings, we'll break every, say, 90 minutes. You will signal Annalise, who is the real boss here. She will let us know when we should stop. For housekeeping purposes, you know that tomorrow will be, the starting times, different occasions, will be different, and Wednesday will start as early as 8 a.m. But for the time being, today we were fine. So I don't have any other messages for housekeeping, but I don't know whether other claimants or respondent want to take the floor and introduce any issues before I give the floor to the representatives from the U.S. Department of State. Mr. Melsheimer or Mr. Darman?
We need to submit some redaction requests for the latest exhibits that were introduced. Today, I think, is the deadline. We're happy to do it today, but we just wanted to give everybody time to prepare for this hearing. So would you like us to do that today?
A redaction request concerning what? Sorry?
Concerning name, addresses, account numbers, all those invoices that were introduced, They have some, I think it shouldn't be disputed, the issues that need to be redacted from it for privacy purposes.
Okay. And then, Señor Bonfiglio?
Gracias, señor presidente.
Mr. Bonfiglio, thank you, Mr. President. If the claimant requires additional time to submit the reductions of its evidence, today is a deadline. Respondent is flexible. Today is a complicated day. However, if it needs more time, the claimant does, and it's reasonable, that's fine.
What are they supposed to introduce today, other than what they already did?
If I understand the response from claimants correctly, today is the deadline to submit reductions of the last piece of evidence that was submitted, if I recall, on 20 November. This in connection with the confidentiality procedural order, either PO 2 or 3. Today is the deadline, that's my understanding, and we wouldn't have any issue to grant an extension to the claimant if they need so.
Either of my colleagues want to say something, which they don't seem to. Then we start our meeting today, we're substantive part of our meeting today, with a presentation by the United States. And I failed to say, to the extent that this has been recorded, I have introduced the members of the tribunal. I will ask each member of the parties to present briefly their delegations before we start the proceedings. Mr. Melsheimer.
Good morning. I am Andrew Melsheimer. To my left is Andy Derman. And then going down to my right, we have Javen Porter, Cole Browndorf. We're all at the law firm of Holland and Knight. Then we have Mr. Jim Finley. Then we have Mr. Luis Kernian. Then we have experts, Mr. Rodrigo Zamora, and expert, Mr. Daniel Emesquita.
And then para México, señor Bonfiglio.
And for Mexico, Mr. Mufillo, thank you very much, Mr. President. Here we have Rafael Arteaga to my right. My name is Alan from Fulfilio Rios. I am the General Director of the General Consulting Office. Then we have Mr. Stefan Becker. And then after that, we have Laura Mejia, Rafael Rodriguez Maldonado. We also have Jorge Escalona, Oscar Rosado, Gary Shaw, and Rodrigo Lustano will be here today. And today, Jorge Asali is also with us. I have two comments, Mr. President, that I would like to make. Mexico's representatives are going to speak in English in 90% of the time. Rather, we're going to speak Spanish 90% of the time, but if in Spanish, you said, I'm sorry, you said English, but you meant Spanish, right? Yes. I meant 90% of the time we are going to speak Spanish, 90%, and some of my colleagues, they will speak English. We're going to talk as slowly and calmly as possible for the benefit of the interpreters. Also, we were wondering if the Secretary has the electronic hearing bundle as well as the other party.
We have the latest USB.
Okay.
And so to finish with housekeeping, I think Annalisa has the final message to us.
Just a couple of points. We know it's quite hot in here. We've already requested them to fix that, and they are doing that. The second point is especially people that are not using the interpretation. If you're speaking in one language and the other person is answering in the other language, if there could be a pause between answer and question, that would be great, so that the interpreters have time to switch the channels. That's it.
Okay, wonderful. So we can now proceed with our agenda, and then we invite, they are already here, Mr. David Biga and Mrs. Maria Muino, as representative of the U.S. Department of State, to make a presentation on their presentation, the amicus brief concerning the treaties. I needed to emphasize that the tribunal is grateful for the U.S. Department to make this submission. We have read it, not only the submission, but also the responses from the two parties, and we are eager to hear you right now.
There.
Okay. Thank you, Mr. President and members of the Tribunal, for the opportunity to present the views of the United States. My name is Mary Muno, and I'm an attorney advisor at the U.S. Department of State, Office of the Legal Advisor. Pursuant to Article 1128 of the NAFTA and Article 14d(7), Paragraph 2 of the USMCA, I will make a brief submission addressing questions of treaty interpretation arising out of the claimants' and respondents' submissions dated September 22nd, 2023. I will address three topics. First, the weight to be given to the views of the NAFTA and USMCA parties in interpreting the terms of the agreements. Second, the methodology for determining rules of customary international law that fall within the minimum standard of treatment under NAFTA Article 1105 and USMCA Article 14.6. And third, I will discuss the issues of consent and waiver. As is always the case with our non-disputing party submissions, the United States does not take a position here on how the interpretations offered apply to the facts of this case, and no inference should be drawn from the absence of comment on any issue. I will begin by discussing the weight accorded to the views of the U.S. on matters addressed in a non-disputing party submission. State parties are well placed to explain the meaning of their treaties, including in proceedings before investor state tribunals, like this one. The United States consistently includes non-disputing party provisions in its investment agreements, including the NAFTA and the USMCA, to reinforce the importance of these submissions in the interpretation of the provisions of these agreements, and we routinely make such submissions. Article 31 of the Vienna Convention on the Law of Treaties recognizes the important role that state parties play in the interpretation of agreements. Although the United States is not a party to the Vienna Convention, we consider that Article 31 reflects customary international law on treaty interpretation. Article 31, paragraph 3 states that in interpreting a treaty, quote, there shall be taken into account, together with the context, A, any subsequent agreement between the parties regarding the interpretation of the treaty or application of its provisions, and B, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. End quote. Article 31 is framed in mandatory terms. It is clear that subsequent agreements between the parties and subsequent practice of the parties shall be taken into account. Thus, where the submissions by the three NAFTA and USMCA parties demonstrate that they agree on the proper interpretation of a given provision, the tribunal must, in accordance with Article 31, paragraph 3a, take this subsequent agreement into account. The NAFTA and the USMCA parties' concordant interpretations may also constitute subsequent practice under Article 31, paragraph 3b. The International Law Commission has commented that subsequent practice may include, quote, statements in the course of a legal dispute, end quote. Accordingly, where the NAFTA and the USMCA parties' submissions in an arbitration evidence a common understanding of a given provision, this constitutes subsequent practice, which establishes an agreement of the parties that must be taken into account by the tribunal under Article 31, paragraph 3b. Investment tribunals have agreed that non-disputing party submissions by the NAFTA parties in arbitrations under Chapter 11 may serve to form subsequent practice. Specifically, I would point you to paragraph 185 of the Mobile v. Canada Decision on Jurisdiction and Admissibility, dated July 13, 2018, as well as paragraphs 103, 104, and 158 to 160 of that decision for context. I also refer you to paragraphs 188 to 189 of the awarded jurisdiction in Canadian Cattlemen for Fair Trade, dated January 28, 2008. To sum up this point, whether the tribunal considers that the interpretations presented by the three NAFTA and USMCA parties are subsequent agreement under Article 31, paragraph 3a, subsequent practice under Article 31, paragraph 3b, or both, the outcome is the same. The tribunal must take the NAFTA and the USMCA's parties' common understanding of the provisions of their treaties into account. I will now discuss the customary international law minimum standard of treatment. Specifically, I will address the methodology for determining rules of customary international law that fall within the minimum standard of treatment. NAFTA Article 1105, entitled Minimum Standard of Treatment, provides in paragraph 1 that the NAFTA parties shall accord to investments of investors of another party, quote, treatment in accordance with international law, including fair and equitable treatment and full protection and security, end quote. As explained in our written submission, the NAFTA Free Trade Commission, or FTC, issued an interpretation on July 31st of 2001, reaffirming that paragraph 1 of Article 1105, quote, prescribes the customary international law minimum standard of treatment to be afforded to investments of investors of another party, end quote. The FTC clarified that the concepts of fair and equitable treatment and full protection and security do not require treatment, quote, in addition to or beyond that which is required by the customary international law minimum standard of treatment of aliens, end quote. This interpretation is binding on the tribunal, pursuant to paragraph 2 of NAFTA Article 1131. Likewise, paragraph 1 of USMCA Article 14.6 requires each party to, quote, accord to covered investments treatment in accordance with customary international law, including fair and equitable treatment and full protection and security, end quote. Paragraph 2 provides that, quote, for greater certainty, paragraph 1 prescribes the customary international law minimum standard of treatment of aliens as the standard of treatment to be afforded to covered investments, end quote. The phrase for greater certainty indicates that the treaty parties understood the language of paragraph 1 to have the meaning set forth in paragraph 2, even if paragraph 2 were not present. According to the same provision, the concepts of fair and equitable treatment and full protection and security do not require treatment in addition to or beyond that which is required by that standard, and do not create additional substantive rights. The FTC's interpretation confirms that NAFTA parties express intent to establish the customary international law minimum standard of treatment as the applicable standard in NAFTA Article 1105. Similarly, USMCA Article 14.6 establishes the USMCA parties' express intent to prescribe the customary international law minimum standard of treatment as the applicable standard in that article. As the United States has explained and as set forth in the ILC draft conclusions on identification of customary international law, to identify a rule of customary international law, it is a, quote, indispensable requirement that both a general practice and acceptance of such practice as law, opinio juris, be ascertained, end quote. This two-element approach is the proper methodology for determining whether a customary international law rule covered by NAFTA Article 1105 and USMCA Article 14.6 has crystallized. Claimants have argued in their response to the U.S. non-disputing party submission in this case that, quote, the United States views the role of arbitral tribunals in developing customary international law as persuasive authority, end quote. This is an overstatement of the U.S. position. As the United States has explained, the decisions of arbitral tribunals do not themselves establish rules of customary international law. Arbitral decisions regarding customary international law should only be treated as persuasive to the extent that they include an examination of state practice and opinio juris, that itself can be relied upon to identify a rule of customary international law as incorporated in NAFTA Article 1105, paragraph 1, and USMCA Article 14.6, paragraph 1. An arbitral award that purports to address the customary international law standard for FET but lacks an examination of state practice and opinio juris should not be relied upon by the tribunal. Claimants also allege that by executing investment treaties, quote, states necessarily agree to have arbitral tribunals play a role in defining the contours of customary international law, including to determine what constitutes the minimum standard of treatment afforded to investments by foreign investors, end quote. This is inaccurate. As the United States explained in its written submission, while the NAFTA and USMCA parties consented to allow investor state tribunals to decide issues in dispute in accordance with the agreements and applicable rules of international law, they did not consent to delegate to arbitral tribunals the authority to develop the content of customary international law, which must be determined solely through a thorough examination of state practice and opinio juris. As a final point on NAFTA Article 1105, Paragraph 1, and USMCA Article 14.6, Paragraph 1, the United States clarifies that incorrect court decisions may only violate the FET standard if they constitute a denial of justice. The obligation to provide fair and equitable treatment under NAFTA Article 1105, Paragraph 1, and USMCA Article 14.6, Paragraph 1, includes the obligation not to deny justice in criminal, civil, or administrative adjudicatory proceedings. Specifically, a denial of justice exists where there is, for example, an obstruction of access to courts, failure to provide those guarantees which are generally considered indispensable to the proper administration of justice, or a manifestly unjust judgment. The threshold required for judicial measures to rise to the level of a denial of justice in customary international law is high. As a matter of customary international law, international tribunals must defer to domestic courts interpreting matters of domestic law unless there is a denial of justice. Turning now to consent and waiver, because the parties have conditioned their consent upon the waiver requirements under NAFTA Article 1121, a valid and effective waiver is a precondition to the parties' consent to arbitrate claims and to a tribunal's jurisdiction under USMCA Annex 14C. A claimant's failure to file an effective waiver before the constitution of the tribunal would result in the dismissal of the arbitration, unless the respondent state agrees otherwise, because the tribunal would have been constituted without the consent of the respondent state as contemplated in NAFTA Article 1122, Paragraph 1. In such circumstance, when the tribunal assesses its jurisdiction upon constitution, it would invariably have to conclude that it lacks jurisdiction ab initio. Finally, I would just emphasize that the United States stands by the interpretations set forth in its written submission. Although we did not address all of those issues today, with that final observation, I will close my remarks. I thank the Tribunal for the opportunity to present the views of the United States on these important interpretive issues. Thank you.
Many thanks, Mr. Merino, for coming here today and for making this presentation. I think you are not expected to take any questions, even though maybe parties will address your remarks in their opening presentations. But so we really thank you, your presence here, and Mr. Biggie as well. And again, I emphasize that the Tribunal is grateful for this contribution from your office and from the U.S. Department.
Okay, thank you.
So then we seem to be slightly ahead of schedule. So we now give the opportunity to Mr. Meschheimer to make the opening presentation for the claimants.
Good morning. Good morning. Good morning. We may run a little bit longer than the allocated 2 hours. I just wanted to give everyone some advance notice on that. We're going to try our best to keep it within the time frame, so I appreciate the United States for ending early. We have an overview of how this presentation is going to go. I'm going to talk to you for a couple of sections, starting with how Mexico encouraged the claimants to invest in Mexico. I'm going to switch over to Javen Porter and then Cole Browndorf, and if there's time for some concluding remarks, we'll have them. But I wanted to start with how I met Jim Finley and Luis Kernion. I first met them in 2020, 3 years ago, almost around this time. They came to me, they told me about how they had entered into 3 contracts with Pemex, the national oil company of Mexico. These contracts required them to purchase workover rigs, drilling rigs, all for the effort of helping Pemex exploit the state's hydrocarbons on behalf of the state. They told me that they had a vision of putting down their roots in Mexico and one day building a productive business. This was a long-term project for them. Unfortunately, their investments didn't turn out as planned. 2 of the contracts ended up in lawsuits, and when they came and saw me, those lawsuits were still sitting before Mexican courts for over 5 years unadjudicated. The last contract, the 821 contract, was the most concerning. Pemex had initiated an administrative rescission, its right granted to it by the government of Mexico, to effectively end its obligations under the contract. And this is a big contract, $418 million over 4 years that Pemex had agreed to do. What they told me, for anyone who's done this, what they told me shocked my conscience. Pemex had issued a work order after, 300 days, 100 days, I forget the exact number. We'll go through it in a minute. After not issuing work, suddenly a work order appears. Pemex insisted that that work order be performed, knowing that our clients couldn't do it. Despite the clear language of the contract, Pemex then proceeded to utilize its government authority and conduct an administrative rescission of the contract. They were stuck in court. They needed help and didn't know what to do. They had lost hope that Pemex had any desire to treat them fairly. They had lost hope in the Mexican court system that their claims could get adjudicated or that they would be heard. This is why investment treaties exist. What happened to Jim and Luis cannot be the normal. If this behavior is condoned, it will be repeated. Investment treaties are supposed to protect against it, and that's why we're here. So let's start with how Mexico invited claimants' investment into Mexico. Mexico owns its own hydrocarbons. Pemex was created by Mexico to exploit its hydrocarbons. It's the national oil company of Mexico, as I said. Mexico is dependent upon hydrocarbons for its revenues. 1/3 of its federal revenues come from oil. Unfortunately, if you don't continue to find new oil, your production declines, and that's going to have a problem for your national coffers. That's what the situation Mexico was confronted around 2004. Its production had peaked, and it needed to reverse the trend. And so what did it look to? it looked to a giant field called Chicontepec, or ATG as you might see in the papers. This discovery was made back in 1926. Production began in 1952, and it's a huge field. Make no doubt about it, there's an estimated 136 billion barrels of oil. The problem with Chicontepec is that it's complex in its geology and has low permeability, which means the hydrocarbons don't flow as easily as one might want. And what Pemex's officials told us in a video that you have, Exhibit C35, this project, once the price of oil hits 75 to 80, is not economic. So how were Jim and Luis involved in this? Luis was working for Pemex building pipelines. He was in communication with Pemex officials. They told him about this new project that Pemex wanted to conduct to help develop the Chicontepec field. They asked Luis, do you know anyone from the United States, because we're right above Mexico and we were experiencing a significant boom called the shale boom in the United States. Do you know anyone who can help us out? Through his contacts, Luis knew Jim. There's Mr. Finley. Getting to know Jim, I can tell you, he's the real deal. He started a company. He has over 40 years of experience in the oil and gas sector, and he's been able to utilize the technologies and the techniques that has helped revolutionize the oil business in the United States. This is the kind of person and company that Pemex needed to develop Chicontepec. Pemex went on a roadshow. It was promoting investment into Mexico, and these are three of the individuals that were first involved. If you ask Jim and Luis, they'll tell you they were promised. Pemex would honor its commitments. The old times were over. It would pay timely. And there is one quote that they vividly remember. Pemex pays, Pemex pays. These aren't the only individuals. There's other players. A gentleman named Emilio Lozoya, he would become Pemex's CEO after Mr. Suarez Capel. He would be appointed by Mexico's new president in December 2013. Alongside him was his, for lack of better words, right-hand man, a gentleman named Froilan Gracia. Let me talk to you a little bit about the introduction into how you're going to do business in Chicontepec through these contracts. It's important to note that Pemex is governed by law. It's not like a normal company. Relevant here is the 2008 Pemex law. Before Pemex could enter into any of the three contracts with us, Pemex had to get approval from the national government of a budget. It seeks the budget, it submits its request to the national authority, it gets approved, and it enters into the contract. In other words, Mexico's government exerts a certain level of control over Pemex, restraining its ability to spend money. Because of this function, all three of our contracts guaranteed our clients the resources have been provided to carry out the work under this contract. One of the first 5 clauses of each contract, assuring our clients there would be money to request for the work and pay for the work. There's a number in the 803 contract, it's $48 million. Mexico's Congress approved a budget for this. Pemex would not have agreed to this contract otherwise. Similarly, in the 804 contract, there's a number, $55 million. Mexico's Congress approved a budget for $55 million for this contract. Pemex would not have agreed otherwise. Finally, it's a much larger number in the 821 contract, $418 million. Mexico's Congress approved $418 million for Pemex to enter into the 821 contract. It would not have signed this contract otherwise. Let me tell you why this is important, these numbers. Our business, I do oil and gas work, our business requires a lot of investment up front. It's capital intensive up front. What we were required to do, we were required to invest with everything you can imagine, set up a business, get down to Mexico, and be ready to perform. That required us to supply equipment and materials, import them into Mexico, transport them to job sites. We had to build roads, we had to build bridges, and get access to each of these sites where Mexico wanted us to conduct the work. In addition, we were also required to spend a lot of capital training employees. This is not an insignificant project. And I put this picture here just to put it into context. We're not talking of driving a drilling rig across the border from the United States into Mexico. All of the equipment you see, we were required to provide in order to perform that work. And it had to be sitting in Mexico, waiting to perform when Pemex asked for that work. Over time, we started in February 2013 with what was called the 803 contract. We submitted a bid, we qualified, and we won. Not long after starting the work under the 803 contract, Pemex offered us another contract called the 804 contract. That was outside the typical tender process. Finally, in before February 2014, we submitted a bid in late 2013 for the 821 contract. I'll show you a quote in a few minutes. We were encouraged to do it. Mexico wanted our investment. They needed our help. We qualified and won that bid. That would become the 821 contract, and as I told you, it's a 4-year contract valued at $418 million. So let's talk about how Mexico treated the claimants and their investments. I have several slides, and you can peruse them. I'm going to give you, for the sake of time, I'm going to give you a summary of the first few. From February 2012 until around January 2016, a 4-year period of time, we entered into 3 contracts, effectively entered into them over a 2-year period. Mexico encouraged us to invest, further our investments in Mexico, and actually stay in Mexico when issues arose. And as I promised, here's a note that Mr. Gracia, again, the number 2 at Pemex at the time, told Mr. Finley. We understand there may be issues of payment, but please, stick around. Invest more. We'll make it right. The slides will show you, and as well as in our briefing, the claimants made every effort possible to obtain the benefits under their contracts. They wanted to make them work. You don't invest money otherwise. Unfortunately, Pemex frustrated the process. They stopped asking for work. At some point, they said they didn't have to ask for work. They sought extensions to the performance term. They sought changes to payment terms. At one point, it went from 20 days to 6 months. You're running a payroll, depending upon revenue, and your counterparty, the state, tells you, I can't pay you within 20 days, I have to pay you in 6 months, you can imagine the effects. Pemex demanded discounts. 2 of the contracts, they ended performance in a process called a finiquito. You've read a lot about a finiquito. It's effectively, they agreed to stop asking for work, we agreed to stop expecting payment for you not asking for work. For the last contract, the 821, Pemex asked for work, stopped asking for work, asked for work again, and that lasted over the course of less than 2 years. Despite having stopped asking for work in January 26, suddenly, in November, we receive a mysterious work order, which is, you are all probably intimately familiar with the work order by now. So how can I explain Pemex's behavior? Pretty easily. I don't think Mexico denies it. This is a graph taken from Jim Finley's first witness statement. I edited it to put a red box around the relevant time period. You can see the 3 green dots are when our contracts were entered into. Very consistent with what Pemex's CEO, or Pemex Exploration and Production, otherwise known as PEP, P-E-P, what he advised in a video that you have. If oil is above 80, times are good and we can perform this, we can do these contracts. But once it falls below, tough times ahead. And that's exactly what happened, and the red dot is when Pemex stopped performing altogether. By April 2016, we wanted to get Pemex's attention. Keep in mind, we have a payroll, we have equipment waiting to work, expecting to work. You try to get Pemex's attention, hey, we're here, they file a lawsuit. The intention was to get Pemex to start performing again under the contract. At the time, and I cannot emphasize it enough, they had not issued a work order for over 105 days. Overall, through the term of this contract, 300 days of not asking for work. This is a graph to show you, and we'll talk about it in a few minutes. We filed the lawsuit in April 2016. The work order shows up November 2016. 210 days later. Here's the burn rate, or what we were spending a month on to keep the employees and equipment on standby. $200,000 a month approximately. We're forced to lay off employees, relocate equipment within Mexico, remove our representative from Pemex's office. We had employees embedded within Pemex's offices to help coordinate this work. Pemex knew all about it. This is not a hidden secret. Yet, in November 2016, here comes work order 28-2016 to drill the Coapa-Chaca 1240 well. We pointed out at the outset of this arbitration, Pemex had told us repeatedly, and I think I read in the briefing from Mexico, it's maybe not in dispute, Pemex didn't have the budget. It had run out of money. To date, I've yet to see where the money to pay for this work order was. We pointed out that it didn't have a drilling permit. In the rejoinder, and I'll address it in a few slides, we now have somewhat of an explanation of a drilling permit, although when you scratch slightly on the surface, it exposes that's not a valid excuse either. This drilling was to begin on December 17th, and I'm going to explain to you why that date is important. But what I want you to take away from this is who signed this work order? A gentleman named David Perez and Luis Gomez. Luis Gomez was our contract manager for the 821 contract. He's not here. He's the one that told Luis Kernian this work order was fake. We've seen no rebuttal evidence to the contrary. So again, I told you to keep December 17 in mind. What Mexico still hasn't addressed, included with this work order, was what's called a movement of drilling equipment. And it's the chart at the bottom. It lists 2 drilling rigs. We've asked, no one has told us, who owns EQ02? Not us. Similarly, I don't know who owns Pemex 404. Not us. These questions remain open. I would assume if I believed this work order were valid, I would have addressed these issues. But if you read in the fine print, and it's hard, you'll have to maybe pull up the exhibit. This work for this movement of drilling rigs shows it was to be between December 15 and December 29, over a 14-day period. That doesn't match the work order that we were given. The devil is in the details. I took this graphic about the equipment from the last version of this movement of drilling equipment that we had. Everyone knew our rig was called the PMX 805, not EQ02. And here's that movement of equipment, the last one we could find in our chart, in our files, excuse me. I edited this and put a black box around 4 wells corresponding to Weatherford, another company performing work for Pemex at the time. These 4 wells include the Coapachaca 1240. We raised the issue. It has yet to be addressed. What's noteworthy, though, these 4 wells were part of a program. Not just the 1240, the 1480, the 122, and the 1680. And why do I bring these to your attention? When Pemex decided to apply for a drilling permit to drill this well, guess what it applied to drill a well permit for? Or apply for a well permit for? All 4 of those wells. There's no other conclusion to reach but that these were assigned to Weatherford, not to us. There's a lot of people who could explain all of this. There's a whole list. I just took the ones that I could find on the work order documents. None of them are here. So why did Pemex do this? Luis Kernian told you. He told you in his first witness statement. He had met with the senior official at Pemex in Mexico City. That senior official told him exactly what Luis Gomez had told him about this work order too. It was fake. They wanted an excuse to try to get rid of this contract. It was a liability to them. They needed to make it look legitimate. But what this senior official, he increased the amount, he upped the ante, is the expression I'm looking for. He told Luis, actually, it wasn't just to rescind the contract. We want to go after your $41.8 million bond. Turns out, as we've shown you, everything this gentleman, Rodrigo Hernandez, told Luis Kernian was true. To date, there are still efforts to go after the $41.8 million bond. So what else does the evidence show us? Pemex started looking for other grounds to administratively rescind this contract. Mexico has argued something about, it's called a PACMA, P-A-C-M-A, obligation. This is effectively 2% of your invoices, goes to support community affairs. Think of playgrounds, dining areas, public works. What's important about this slide? Suddenly, shortly a month after we file our lawsuit to get Pemex's attention, the PACMA area begins sending notices to Luis Gomez, the contract manager of the 821 contract, about these PACMA obligations. These were obligations that had been assigned in January 2015. Let's recall, during this period of time, asking for work, not asking for work, asking for work, not asking for work, bleeding us of cash. Yet here we are, Pemex not thinking it has to be obligated on the contract and pay us, ask for work and pay us, but yet it expects money from us in return. Why didn't we hear about it before? We have in evidence now, Luis Gomez apparently starts writing notices to Finley in December 2016. Why is that date important? That's after the work order. What I noticed about this particular document, the reason why I have this graphic, notice who didn't sign. Everyone I have seen in every document is very careful to either initial or sign something with their name on it. This document, which has been submitted to you as proof of notice, someone's signature is missing, Luis Gomez's boss. You'll find that in others. That's why I choose the words carefully when I say he began writing notices. I don't know if he sent those notices. Into March, Mr. Gomez was asking PACMA to gather evidence. Why do I have this graphic up? You all ordered Mexico to disclose documents. This document references a February 9 memo. Apparently, Luis Gomez had written to the PACMA area on February 9. I have not located that document. This document is also referenced in the antecedentes part of the memo, and everyone within Pemex is very careful to create a record of every communication related to a topic. The February 9 memo is in the antecedente section, but there's yet another document I haven't seen. From the documents that we have, our ability to determine when Mr. Lostenow first appeared is a May 8th, 2017 memo. In this memo, he says, we have a lawsuit pending with Finley. Proceed with the administrative rescission because we have to impute breaches on the contractor. We've repeatedly asked, and Mexico was ordered to disclose, the memo that was attached to this May 8 memo. As you can read, it's dated May 3rd, 2017. The annex box is checked. Adjunto, which means attached, is written in the text. Where is that memo? That memo discusses, and I'm using air quotes, among other things. What other things was Pemex thinking about? In June 2017, what we have, right before the administrative rescission, again, based on the work order 28-2016, Pemex applied for the drilling permit. This was important enough that you ordered disclosure of documents related to it. Like we saw earlier, that includes the Weatherford wells, as I like to call them. Pemex submitted information required by Article 27. Why do I point that out? That was the excuse we heard in the rejoinder. That we did not provide something called a detailed program. Therefore, Pemex couldn't obtain a drilling permit. We should have received the information that Pemex submitted to the CNH, which is the authority to issue drilling permits. They didn't need that information from us. We don't do that. They had every technical information available to them to drill this well. So why do I bring this up? I have the timeline here about how long it takes to obtain a drilling permit. In the rejoinder you read, we were obligated to submit a detailed program 8 days before drilling. According to the application and the receipt of the drilling permit to actually drill the well, it took 2 months? How was that going to work? By the end of July 2017, Pemex notices its administrative rescission. And I point this out, and I apologize that it's in Spanish, but I think it's important to read the actual language. They base it on 2 clauses, 15.1b and 15.1s of our contract. Now, if I didn't mention before, I want to make sure we understand an administrative rescission is a special power that Pemex has because it's part of the Mexican government. It effectively allows Pemex to adjudicate and render justice, if you will, under a contract. Question: why didn't Pemex look at clause 15.1r? It comes right before 15.1s. I would note, if you look at this document, Luis Gomez's name appears once again. He initialed it. And again, this is in giving him more detail of this document. It's Exhibit C-104. Clause 15.1 is important. We've talked about it. We've received argument about how it's supposed to be interpreted. My question is, how can you ignore it? It's pretty clear. It says Pemex cannot invoke this special power that it is given unless and until there are 15 unfulfilled work orders. I can tell you I wondered why this process occurred. It's an unusual system. Why 15? You got to look closely at the contract. I encourage you to read it. I've given you the provision. And actually, when ultimately a unilateral finiquito, the ending of the performance under the contract, Pemex recognizes this provision. It was aware of this provision. This provision is effectively, it contemplates the contractor not fulfilling a work order. And what does it do? It says if you don't fulfill the work order, we will penalize you $17,500 for each day that you don't perform work. Not uncoincidentally, after 15 days of not performing the work order, we will consider the work order unfulfilled, and we can issue a new one. So there was a process under this contract. We're going to penalize you for delayed performance under a work order if you don't perform it. If you accumulate 15 of those, as Pemex, we've had enough, and we can invoke the special right of administrative rescission. If you do the math, 17,500 times 15 times 15, roughly equivalent to about 1% of the contract amount. Pemex was required to behave better. Not just by law. Our contract specifically says it. They had a duty of good faith to cooperate, not intentionally mislead, and to perform the contract for the mutual benefit of us and them. Yet they blew past Article 6.6.1 and Article 15.1R. Worse, Clause 15 gives a secure right. To the extent their argument holds any water, that they can terminate based on one unfulfilled work order, which defies the language of the contract, they had to give us an opportunity to cure. I've seen it says may, not shall. Couple that with your obligation of good faith under Article 3. That may turns into a shall. Shortly after, Pemex obtains its drilling permit for the Coapachaca 1240, administratively rescinds the contract. In September, we go to court, administrative court, special court, that deals with things done in an administrative manner to challenge Pemex's rescission of this contract. And I put in September, Pemex agreed to suspend the elaboration of finiquito for the 821 contract for a reason. We'll get to that in a second. What did Pemex tell this administrative court? It told this court that it had two justifications for rescinding this contract. One, not performing work order 28-2016, and two, this PACMA obligation. For the work order, it said, hey, court, we have the right to do this under 15.1b. What didn't it tell the court? Pemex did not tell the court, yes, but there's a clause 15.1r that is relevant and important to this. And I told you why I put about the agreed suspension to the finiquito process. In May 2018, despite having this suspension process and despite us being in court, Pemex apparently had a meeting at its offices in Mexico City to plan a claim against the $41.8 million Durama bond. From my review of the documents, this is the next time Mr. Lostenau's name appears. Now remember, he testified to you, and we made it twice, made it a point. He had no involvement in anything related to the administrative rescission of this contract until he was promoted to his current position in 2020. Yet, here he is again, copied to a communication about the administrative rescission. We look forward to hearing from him about this meeting that he attended. I say he attended, I highlighted the language, and it's someone who fits his job title at the time. Now, I'm glad you raised Mr. Keosayan's lack of appearance, because now we're at the interesting part. The administrative court would rule on October 4, 2018. We know this in hindsight, but at the time, we didn't. Luis Kernian met Mr. Lostanow at a restaurant called La Aceituna in Mexico City. It was arranged. Mr. Kernian testified. He recalls in his translation, he'll share with you the Spanish when he testifies. Your companies are done, is the effective translation into English. Now, when you hear a story like Luis's, and you read a witness statement like Mr. Lostanow's, as a lawyer, I have a responsibility to verify the facts. So I arranged a phone call, a Teams meeting with Mr. Rob Keosayan. I wasn't trying to get him to concede anything. I was trying to understand the facts of what happened. It was you view it. There's two takeaways I want you to get from that Teams call. Mr. Keosayan knows Mr. Lostanow. Again, Mr. Lostanow's first witness statement gave me an entirely different impression. The second, Mr. Keosayan knows he was recorded. That video starts at a very awkward position. We had exchanged pleasantries, and I can't hit the record button until I have permission. I have ethical obligations. Not long after that call, I get an email from Mr. Keosayan. We had discussed during the call, I asked, watch it, how do you communicate with Rodrigo Lustanow? WhatsApp messages mostly. Can you find them? And you'll see him fumbling around. He can't find them. But let me look and I'll get back to you. I get an email. I found some messages. His words, not mine. I found some messages from those days. Suddenly, my mobile phone starts ringing. I was trying to invite Mr. Keosayan to another Teams meeting in response to his email. I wanted to have a proper conversation with Mr. Keosayan. I wanted it recorded. Mr. Keosayan called and left me this message. Well, we're having a technical. Would now be a good time to pause so we can get the technical deficiency? Good.
We'll pause for a while until we sort this out.
He's gonna check.
A 10-minute break. So.
This is Roberto. This is Roberto. I did just requested, Rodrigo confirmed to meet us at is Roberto.
Okay, we are all set again. So, Mr. Melsheimer.
Señor presidente, por parte de la delegación de México,
Mr. Chairman, on behalf of the delegation of Mexico, we feel we must make a clarification. We don't want to be disruptive with respect to the claimant and claimant's time. At certain moments, it's not clear to us whether the attorney for the claimant is offering testimony or is recalling the facts. But thus far, there's no witness statement to the record of this case that includes a witness statement by Mr. Melsheimer. So we consider the situation a bit irregular, and we will delve further into depth on this point when it comes to offering our rebuttal. But that is something that strikes us.
But what do you mean when you say that he's delivering a testimony rather than making a summary of an opening statement?
hasta donde tenemos conocimiento, señor presidente.
As far as we know, Mr. Chairman, there is no record of this recollection of facts being presented by Mr. Melsheimer regarding the conversations and the details of those conversations with Mr. Roberto Kioseyan, and particularly what has happened around the days that he's been discussing. It's something that strikes us, and we want to draw your attention to it.
Comment, and I ask Mr. Melsheimer to continue with
Yep.
his
So,
presentation.
again, I received an email from Mr. Kioseyan that said he had found some messages from those days. Again, he's referring to the WhatsApp messages that he told me he was going to be looking for when we had our Microsoft Teams meeting. Suddenly, my mobile phone starts ringing. I can tell it's from Mexico. I don't want to answer. I'm trying to do another Teams meeting, but I got this voicemail.
This is Roberto. I did find some messages where I requested, Rodrigo confirmed to meet us at La Aceituna during those days. I did find that. And he also found that we had a conversation with his boss, about a possible settlement with him and with the authorities at the court. There was a conversation to that effect. And his boss was the one that was negotiating that, Alfonso Watts. So if you can discuss that, tell me when. Bye.
Moments after leaving this voicemail, my office line starts to ring. And you're confronted with the situation of, you have the fish on the hook. Do you want to let it go? I picked up. Again, we've seen this. We have raised this to you before, but it's helpful to remind you what transpired. Mr. Keosayan told me, and if he were here, he'd have to admit it, he found WhatsApp messages. He gave me the date of the meeting at La Aceituna. I did not have September 26, 2018 before this conversation. During that call, he mentioned again Mr. Wati, G-U-A-T-I, Rojo. He mentioned Mr. Wati Rojo again, Mr. Lustinel's boss at the time. Apparently, there were conversations about a settlement with the court. Same thing as the voicemail that he left on my mobile line. Now, during the call, he also told me that he met with the judge. We've come to learn that apparently it's okay to meet with the judge in Mexico. He, Mr. Keosayan, met with the judge with a gentleman called Juan Jose Pauyada. Who is Juan Jose Pauyada? Juan Jose Pauyada would become our lawyer. He would challenge the administrative rescission that would arrive a few days later. Juan Jose Pauyada would then terminate his representation of us. Would you like to know why? He was appointed to the board of Pemex.
This is Roberto.
It did not take long for Mr. Roberto Keosayan to change his tune. I tried. I sent him follow-up emails. You've seen it. It's in evidence. He called Luis Kernian. Luis didn't pick up. Sent Luis text messages. You have that as well. And you have Luis's testimony of what was said. Apparently, Mr. Keosayan had been in contact with Mr. Lustinel that day. Mr. Lustinel was not happy that Mr. Keosayan talked to me. Understandably. Within, 2 months? By March 22nd, he's sending you all a notice disclaiming everything. Completely disavowing everything, despite a 1-hour recorded call on Microsoft Teams. Well, everything that, or what Mr. Lustinel told Mr. Kernian at La Aceituna turned out to be true. Not long after that meeting, the administrative court issued its decision. It noted everything that it accepted, everything that Pemex told it. They had the right to administratively rescind the contract based on clause 15.1b and 15.1s. The court, it says, failed to consider, that might be generous, clause 15.1r. Now, you will hear from Mr. Emescazita. That court had a duty. That court was supposed to look at the allegations presented to us, even if not precisely made, examine the contract and make sure the government authority was exercising its unique role to conduct an administrative rescission properly. This court did review that contract. I've given you the page numbers where I could find all the different provisions that it cited. Yet somehow, this court did not see Clause 15.1R, which is the clause immediately before one of the bases that Pemex used to administratively rescind the contract. We tried to challenge the administrative court's decision. Again, that was Mr. Pauyada, who now sits on Pemex's board. While we were doing that, the litigation over the 803 contract, finiquito, and just to jump you back to my timeline, the 803 contract and the 804 contract, the parties had agreed to enter into a finiquito with us reserving our rights to make claims for amounts that we believed were owed. When we filed our amparo challenge, which is, as best as I understand it, a collateral attack on the judgment, those finiquito litigations, too, remained unresolved. By March 2020, the Supreme Court of Justice dismissed our appeal for the amparo challenge. I put this, there's a remark that was made that we did consider it futile. We dismissed, in order to pursue this ICSID arbitration, we had to dismiss everything that we were aware of that was outstanding. We sent notices to every court. You can't deny it. For some unknown reason, it takes the Mexican Supreme Court over a year to notify you when it decides not to take a case or reject your case. I had no idea that it had already decided against us or declined our appeal when we submitted this arbitration. So in March 2020, we initiate this ICSID arbitration. Again, I tell you, when you're presented with facts like the ones we have, it gives you that feeling that this isn't the way a host government is supposed to treat an investor. We discontinued the proceedings. You all were constituted by October. There was a back and forth about how to interpret the provisions of the USMCA and its interplay with NAFTA. By November, despite this arbitration being ongoing, in November, Pemex advises us that it was proceeding with the finiquito, or the, and I'm using air quotes, settlement of the 821 contract. There's an interesting story about that, but we're short on time. Pemex issues, or it's dated, I say issues, it issues a unilateral finiquito on November 10. I write to Mexico's counsel, guys, we're in the middle of an arbitration. Let's let you all do your job and move forward. Once this is all resolved, move forward. You can read the response for yourself. We went through and tried to get an interim award. We understand that maybe not the time. We had our first session, the day of our first session, when we first met. Guess what we received? A claim on the $41.8 million Durama bond. So despite knowing this arbitration was ongoing about what had happened about the 821 contract, Pemex continues its quest. After issuing the finiquito, Pemex officials start to appear at our former attorney's offices. Again, this is in prior briefing, demanding that she accept it. We took a picture. I was aware of it. I've tried. It's like, I'm the lawyer. Tell me about these things. Nevertheless, they went back and taped the documents to her door. So a couple observations of this November 10 finiquito. I told you before about clause 6.6.1 of the 821 contract. Guess what Pemex cites in its finiquito? That clause. Now, it emphasizes the wrong part. It enjoys the part that says a penalty is going to be applied for 15 days. But then it ignores the second half of the sentence, that if that happens, the work order is considered unfulfilled and you're going to issue a new one. Despite this, in the finiquito, Pemex demands that we're supposed to pay it in addition to administratively rescinding the contract. We also owe them $262,000 for the delayed performance. Mr. Porter will talk about it later, but it's worth noting I don't have it here, but when you read that finiquito, look at clause 12. I believe it's clause 12 or 8. My Roman numerals may be. It clearly says the 821 contract will close once all amounts paid under this finiquito are made. Yet, we've received voluminous pages of argument about how contracts die at certain points in time in Mexico. Another provision that strikes me from the finiquito, again relevant to your analysis, Mexico, in addition to claiming the $262,500 for the delayed 15 days of performance of Work Order 28-2016, it says we owe it a penalty of $41.8 million. That's the Durama bond. This is no ordinary bond, as we've seen in the briefing. This is security or an asset that Mexico has. Now, I told you about the November 10, the finiquito, and I question, it's a curious document, and it's very curious what transpired. I received the timeline from Mexico, and read it. They tell us on November 10, Pemex unilaterally formalizes the termination of Contract 821, citing R43, which is what we just saw, the provisions. But on November 19, it's curious language. It then says, although we had the authority to unilaterally terminate the contract, we're going to publish notices. And they want to publish notices that if you don't attend, we're then going to carry out a finiquito unilaterally. So you either did or you didn't on November 10. Saw another November 22nd. Again, we're going to notify you, put it, and curious, why are we publishing this in the paper? It's a state act. Again, we do it on November 22nd. If you don't attend, we're going to proceed to unilaterally administratively rescind the contract, or engage in the finiquito. I thought you had already done it on November 10. And then, it's interesting, we have another process of this. On December 15 and 16, again, if you go back to the pictures of the guys doing the fist bumps in the street with the face mask because it was COVID at the time, then they tell us, they notify us of the finiquito dated November 10. So, wait, we're back to the finiquito, not finiquito, back to being the finiquito again. You shouldn't have this many questions for a significant matter like this. So with these facts, I want to turn to Mexico's violation of NAFTA and the USMCA. We appreciate that this factual scenario crosses borders, if you will, not just Mexico and the United States, but between two treaties, the USMCA being the successor to the NAFTA. There's a bunch of provisions. Here's what we know about it. You need to make a choice on which treaty to bring your claim under. If you make your claim under the NAFTA for an investment, you need to make your claims under the NAFTA for the investment. If you make your claim under the USMCA for your investment, you need to make your claims under the USMCA for your investment. There is a footnote that does say, if it goes under both, we encourage you, or we don't give consent, unless you go towards the USMCA. When in doubt, go to the USMCA. There are several arbitrations pending, trying to understand the language. I don't think it's that complicated. We welcome Mexico to present a more thorough analysis on the interplay between these two treaties. I've not seen it so far. Our claims are straightforward. I appreciate there's a lot of facts, but the claims are relatively straightforward. Mexico's and Pemex's acts with respect to the 821 contract crystallized in October 2018 when that administrative court ignored our rights. And some would contend, and we do, it didn't comply with its duty to protect us against these types of things, and issued its decision, validating Pemex's administrative rescission of the contract. We brought claims under NAFTA because the relevant event occurred during the effectiveness of the NAFTA. Mexico's and Pemex's acts towards us with respect to the 804 and the 803 contracts were continuing when we had to discontinue them to initiate this arbitration. As a consequence, because the USMCA was in effect at the time, we brought the claims related to those contracts under the USMCA. National treatment. Same provisions, effectively. Here's our comparable that we have. We have a contract, according to Mr. Asali, nearly identical to the 804 contract, entered into between two Mexican nationals. It's there in the contract. I don't need to prove who owns that company. It says it, they're Mexicans. Were we in like circumstances? Yes, we were. Again, remember the context how we started this presentation. Mexico, or Pemex, lacked money. We were not the only one that it wasn't paying. But based on this, we were the only one that did not get paid. Like us, for the 809 contract, Pemex wasn't issuing work orders. I'll point this out, this slide, again, who signed the finiquito for the 809 contract? One of the same people who signed our work order. He would have been a very good person to hear from at this hearing. Treatment no less favorable. Ultimately, the Mexican nationals got paid. Within 3 years, of entering their finiquito, Pemex issued them a check, or maybe a wire transfer, I don't know about an actual check, but sent funds to these Mexican nationals. Paid them a daily rate for the amount of the work that it didn't request. When you do the math, that contract had a value of $24 million, a minimum value. The contractor had been paid over $8.4 million. They ultimately got paid, as a result, $15 million. Now, I cite to the Acta de Extinción for a reason, not just to show you that Mexican nationals who were in like circumstances were treated more favorably than we were. They did not have to go through 5 years of litigation as we did for the 803 and 804 contract. They did not have to suffer through an administrative rescission based on a fake work order. They got paid within 3 years of their finiquito. Paid for days that Pemex did not request work. And why do I put the Acta de Extinción? We've heard a lot of argument about whether contracts are still alive or not still alive. Read it. It makes clear those contractors had the exact same understanding as we had when it comes to what these contracts, the effectiveness, and how long they remain effective. They would not have entered into this otherwise. Second claims, fair and equitable treatment. Pretty straightforward. You have an obligation as a host government not to destroy or frustrate an investment by improper means. That's what Waste Management, the Tribunal of Waste Management said. I think your facts fit squarely within this definition. How can they not? Again, another tribunal, these tribunals are very distinguished as you all are. This tribunal decided, look, it can be conduct that's arbitrary, grossly unfair, unjust, idiosyncratic. You can read it. I don't need to do it for you. But what's important is that this standard is not concrete and set in stone. It has to be adapted to the circumstances of each case. This is one of them. We have another decision from Merrill and Ring Forestry. The standard protects us against all such acts or behavior that might infringe a sense of fairness, equity, and reasonableness. Like I told you, when I met Jim and Luis 3 years ago, hearing the facts that I've laid out before you, it's hard to find what happened was fair, equitable, or reasonable. And this is from the briefing, and I won't elaborate, but it's pretty clear what happened from a macro perspective, and I recommend you do it. Look at what happened. Everything that we told you turns out to be true. The project didn't turn out as Mexico had planned. The price of oil was collapsing. That's a big liability for a $400 million contract. And what's a good way to get out of it? But what really should eat at everyone here, this was an administrative contract. Mr. Asali tells us in his report, these are special contracts. We were supposed to be protected by the Mexican judicial system against abusive conduct. We weren't. And with that, I'm going to turn this over to my colleague, Javen Porter, who's going to talk to you about claimants and their investments.
Claimants and their investments, I hope what I can do in this short period of time is clear up any misunderstanding that may have been raised by Mexico and its briefing. And I think that's important to describe these investments in detail today because there has been some confusion raised. But what's also important is these two men that you will hear from, Jim Finley and Luis Kernion, through their companies committed $35 million worth of capital through equipment and other purchases to Mexico to honor these contracts. And I hope that we can detail that exact commitment today. You see, Mexico in its arguments has moved the ball. In its counter memorial, they first said, we have not proven who made the investments. Claimants have not shown who made them. We answered that question. We submitted witness statements and a QuickBooks ledger that detailed the exact purchases that were made. The ball was moved. In the rejoinder, Mexico argued that the only proof of these investments comes from witnesses who have a direct interest in the outcome of the case. Again, we answered that call by submitting a letter on November 14th and asking to submit even more evidence, documentary evidence. We submitted over 600 pages of invoices to back up the purchases that were on that ledger, which is C-148. And I'm sure you're going to hear today from Mexico how we still haven't met our burden. But again, we will meet any question you ask and answer it today, and we're not going to shy away from the money that was spent in Mexico by these two men and their companies. And it's interesting that Mexico raises this argument today because Mexico moved on administrative rescission on the A21 contract on two grounds, mainly the work order and PACMA. And nowhere in that administrative rescission did Mexico raise that we didn't have the equipment in Mexico. That was interesting. Mr. Lucinal said, find me breaches in that May 3rd letter. There was no breaches found for equipment not being in Mexico. And when I'm talking about these investments, they mainly take place through three companies, Finley, MWS, and Prize, and those are our claimants. Under the treaties, an investment is essentially every asset that an investor owns or controls that it directs to the host country. An investor under NAFTA and the USMCA, it can be an enterprise of a party. And an enterprise can mean any entity that is constituted or organized under the laws of a party. And here that is the United States. And Finley Resources, MWS, and Prize are all constituted under the laws of the United States. That's what matters. And this was not a small operation. You're going to hear names of other companies. It was not a small operation because it was over $500 million of contracts. You couldn't just do it through one company, and it couldn't be exactly simple. Two men, Jim and Luis, put together a complex group of organizations to meet the needs of the contracts. And they did it through these companies, and these companies committed the capital. And you'll hear them explain that. We have some charts here. And the purpose of these charts is to try to simplify the process. And you can look first, we're going to talk about Finley Resources, and this is some of the investments that Finley Resources made. First, Finley Resources was a party to the A21 contract. So, Finley Resources made an investment through the A21 contract and also has an investment in the A21 contract, which is the claim to the money, which is an investment under NAFTA. Finley Resources also owns and controls Drake Finley, Mexico. And any money paid by Pemex to Drake Finley, Mexico, was reinvested back into Mexico to support the contracts and the investment. And the reason for that is because Pemex had lapses in pay. We had to reinvest capital, keep the operation going, to be able to perform. There was no distributions taken by the claimants in this case. Finley Resources also owns and controls Drake Mesa, Mexico. Drake Mesa, Mexico, as we have shown in our briefing, owned the equipment in Mexico. The equipment was imported to Drake Mesa, and Drake Mesa took ownership and had ownership in Mexico of all of the equipment. Finley Resources also provided labor to make the equipment operational. That means that they sent their people to Mexico to be able to perform, to make the equipment operational. And what that means is they went there to make the drilling rigs meet the exact specifications that Pemex required. And Pemex checked that box. They said this equipment is okay to work on this project. At that time, they were not asking questions about whether it was there. Finley Resources also provided capital, $1.3 million approximately, for the drama bond. That's the same drama bond that Mexico is trying to seize upon today. And Finley provided capital to start the investment, to buy the equipment, and to keep the investment going throughout the entire time that Pemex was not paying and the lapses in pay. MWS Management, also a party here today. It was a party to the 803 contract and the 804 contract. There was no money paid in the 804 contract by Pemex. They canceled both work orders that they issued under the 804 contract. Under the 803 contract, any money that was paid was reinvested back into the investment. The same issue with before with Finley. Any money that came back, they had to send to keep the operation going. MWS actually provided equipment it already owned and an in-kind purchase. At the time of these contracts were signed, they had a short period to be able to put a massive amount of equipment together. You're going to see this in a second when I show you some of the rigs and what was purchased. It was not a little project. It was a lot of equipment. And this was during the boom of the oil and gas industry, 2012, 2013. Equipment was scarce. So what did MWS do? It pulled from its own equipment and it sent it to Mexico. That's an investment. MWS provided labor to make the equipment operational. One of those individuals was Alan Claiborne. He was sent to Mexico to be able to make sure that the drilling rigs under the 804 and the 821 and the workover rigs under the 803 fit Pemex's needs. And MWS also provided capital, the same as Finley Resources, to be able to perform under the contract initially, to buy the equipment, and to keep performing when Pemex wasn't paying. Prize Permanent Holdings. Prize, it owned and controlled Basel. Basel is a party to the 803 and 804, and again, any money Basel received in the contracts was put back into the investments. No distributions were taken. Basel also provided other equipment to be able to build roads, such as backhoes, trucks, to get to the drilling rigs in remote areas. So Basel was providing other equipment besides rigs to meet the needs under the contracts. Prize also owned and controlled, as a majority owner, of Drake Mesa. Drake Mesa is a party to the 821 contract, and it also was the owner owned the equipment, as I discussed a minute ago. Prize also owned and controlled Baku. Baku purchased real estate. Prize provided the capital to purchase that real estate. Baku was a mere holding company. Prize provided the capital to purchase what we call the yard. We purchased what we call the yard and two other pieces of real estate in Mexico, which were investments. They were assets under NAFTA and the USMCA. Real property. Prize also owned and controlled Drake Finley, Mexico, which again reinvested any capital it received from Pemex back into the contract. I'm going to show you some examples of these investments. This is the yard. You can see when it was first purchased in that top left picture that it was just a field. It was not operational for a company to provide services to Pemex. So what did Finley, MWS, and Price do? They went to work. They committed capital. They changed that yard into an operating yard to be able to provide services. Also, it became a holding yard for when Pemex made them bring the equipment back during the contracts, something that cost them about $300,000 each time it was done. That was a commitment of capital under the contracts, and the yard was an asset under the USMCA and NAFTA. It was an investment. Drake Mesa, Mexico, imported the following rigs and related equipment. And it's interesting, when you look at these rigs, and something I've even learned some about in this arbitration, a rig is not just a rig. It's related equipment. A lot goes into it. It's people. It's tool sheds. It's pumps. There's a mud tank. There's other things that go along with it. And I have a list here we can look at as well. But there were 9 workover rigs, and you can see how much those pieces of equipment cost. They were expensive. Totaled $18 million. That came directly out of Finley and Price capital to start the contracts. Mr. Melsheimer mentioned about how these contracts were, you had to provide the capital up front on your own behalf. That's exactly what the claimants did. And they imported them from the United States, and they put the ownership of the rigs in Drake Mesa, Mexico, permanently. You will hear Mr. Finley talk about that. This was a long-term investment. We were not going to Mexico to do this one contract and come back. We were sending this equipment on a permanent basis. Here's an example of one of the drilling rigs that was purchased under the contracts for $3.6 million. And if you can see all of the parts of the drilling rig that go along with it. It's not just the rig. It's a lot. And it's a high capitally intensive purchase. And here's some pictures of that equipment at work in Mexico. That top left picture is a drilling rig, and that middle top picture is a workover rig. And here you can see some of Finley, MWS, and Price's employees at work, drilling and working over rigs in Mexico. On that one of those last slides, it had auxiliary equipment and trucks. The trucks were a big purchase, around $4 million based upon C-148. It's because you had to transfer and transport people and the equipment to where the wells were being drilled in Mexico. And here are some more examples of all of the pieces of equipment that go along with drilling a well, such as a generator and other tanks and pumps. Now, let's talk a little bit about the arguments that Mexico raises concerning these investments. And respectfully, it's difficult to understand some of Mexico's objections. So we do welcome the opportunity for them to explain exactly what they mean when they say that no investment was made in Mexico. But my interpretation is that Mexico's arguments are sometimes superficial. When you do get past that initial layer, they lack real merit, and they seem to confuse. They seem intended to confuse. This is because the definition of investment under the treaties is broad. It's not intended to constrict what an investor can bring. It's intended to be broad. But Mexico takes the opposite position and looks to constrict the protections that were provided to the people that invested in their country. For example, Mexico argues that Finley raised a breach of NAFTA before a Mexican court. But if you get past that initial argument and you look at actually what was raised in the Mexican court, that is not true. Mexico said that their contract was protected by Article 1105, and what that meant was the administrative court was required to interpret the A21 contract in a matter that was most favorable to the U.S. investor. Claimants merely raised a canon of construction related to NAFTA. It had nothing to do with the merits of the breach or any of the facts we talked about today when referring to NAFTA. In fact, today is going to be the first time that any court has reviewed or any panel has reviewed 15.1R, and we do welcome that opportunity. Now let's talk about Drake Finley's waiver. Mexico argues that this entire arbitration should be dismissed because Drake Finley submitted a piece of paper with its reply. And it ignores the fact that Drake Finley had long before that discontinued any proceeding that it had in Mexico. And you see, every tribunal that has been faced with that set of facts has come to the same conclusion. That piece of paper is a mere formality. What is material is whether or not you discontinued the proceeding. And we did that. And it's interesting, the only party in this room today that continues to make a claim in Mexico is Mexico. And they're coming after the drama bond. They're not going to let that up. They're the only party that has a claim today in Mexican courts. Now let's also talk about one of Mexico's arguments regarding the 821 contract. Mexico argues that the 821 contract is a services contract, and therefore it falls under the following exception. And you can see here, investments mean, and if you look down, but investments does not mean claims to money that arise solely from I-1. And I will give you a second to read what I-1 says. Mexico, in their rejoinder, paragraph 264, says, claims to money arising solely from commercial contracts for the sale of goods or services, and then ends. Falls under the exception under I-1. But I-1 continues. It says what Mexico says, but it says also by a national or enterprise in the territory of a party to an enterprise in the territory of another party. Clearly, I-1 is intending to exclude as an investment mere cross-border trade. When I send services without making a commitment of capital, as described above. And today we have proven, and throughout our briefing, we have proven that claimants committed capital and investments to Mexico. This was not a mere cross-border trade. Mexico also says that claims to money are not investments. Again, this is a misreading of what the NAFTA protects. Claims to money are investments if they involve the kinds of interests set out in subparagraphs A through H. Now let's look at that, A through H. We have an enterprise here today. I showed you 3 earlier. That was an investment made by claimants. Claimants also have G. They have the yard. They have other property, real property, such as the equipment. Claimants made investments in A through H. Now, if we go back and we read that, what does investment not mean? It says that investment does not mean any other claims to money that do not involve the kinds of interests set out in subparagraphs A through H. This does not apply in this case. Therefore, claimants have an investment to the money it was not paid under the 821 contract, because the 821 contract is associated with the equipment that was sent to Mexico. Also, claimants made an investment through the drama bond. Mexico argues that the drama bond is a contingent liability. They ask you to look at the drama bond without thinking about the 821 contract. Now let's think about that for a second. How is Mexico going after the drama bond? What is that based on? It's based on their fake work order, which they issued under the 821 contract, and the administrative rescission under Clause 15 that they issued under the 821 contract. You cannot review the Durama bond without thinking about how they are going after the Durama bond. It's through A21 contract. The Durama bond must be analyzed with the A21 contract. Also, Mexico is treating that as an asset. They believe they can go after that $41 million. And they're trying to, still today, in Mexican courts. Another objection that Mexico makes that is intended to confuse is they say that the A21 contract claim is not a legacy investment as described under the USMCA Annex 14C. And what the USMCA Annex 14C says is that for a legacy investment to be brought under NAFTA, it needed to be in existence at the date of the entry into the USMCA, which was July 1, 2020. Whether or not this is even a legitimate argument that Mexico is making is beside the point, because the facts that Mexico relies upon are untrue. And the reason for that is the Finiquito, the one that Mexico drafted unilaterally, we had nothing to do with how that was drafted or written, says the contract is still in force. So Mexico says since the A21 contract ended at the Finiquito or the administrative rescission, that we have no investment at the date of the entry in the USMCA. Well, let's read the Finiquito. Let's see what it says, the one they drafted. The closing of this contract, the A21, will take place once the contractor pays the indicated quantities in full. We haven't paid them a dime since then. Also, the A21 contract backs this up. It says the term of the contract will end until the settlement is formalized, or in the event that it results in balances in favor of any of the parties, until the date on which the corresponding amounts are paid in full. Mexico wants us to pay the Durama bond. We're not paying it. No one has paid anything since this Finiquito. The contracts are still alive. Mexico also makes a curious argument. It says we cannot associate an investment with one of the contracts or multiple of the contracts. They offer no support for that argument. But again, Pemex knew at the time we were using the equipment that was used under the 803 and 804 contract for the A21 contract. In fact, they signed off on it. Everyone was aware that all of the rigs that we had used in 803 and 804 were also being used for the A21. And we still made more purchases. We still made more commitments. You'll hear from Jim Finley, Luis Kernian, that Froilan Gracia invited them to make more investment. And they made more investment. Now let's talk about Mexico's time bar arguments. So Mexico says that claimants or a reasonable person should have known of the breach and the loss before March 25th, 2018. That's just not true. And the reason it's not true is until October 2018, claimants did not know that a Mexican court was going to condone Pemex's actions. And until that point, we still had faith in the system, in the Mexican court system, that it will correct a wrong that was being taken through Pemex. You see, on that date of October 2018, these facts were known for the first time to a reasonable person. Pemex had issued a fake work order in November 2016. In July 2017, Pemex had rescinded the A21 contract based mainly on that work order. In September 2018, at La Aceituna, Mr. Rodrigo Lucinal told Luis Kernian that your companies are done and that the Mexican court is going to back up Pemex. And he told him the date, October 5th, 2018. And guess what? On that date, the court came through. That is when a reasonable person would have known this has gone beyond a mere contract dispute. This is going into what an investment breach. Not before that. And you see, Mexico wants to have it both ways. They want to say we're bringing up contract claims here, and they also want to say we knew about an investment breach before. And you can't have it both ways. Yes, you will have to interpret the contract and take note of the contract, because you have to know how we were wronged in the Mexican court system and how Pemex administratively was rescinded by ignoring 15.1R. But tribunals have said that is fine. You can do that. But we're not bringing a contract claim. Now, Mexico's time bar arguments regarding national treatment. Here are some important dates, and we'll come back to this in a second. But first, I want you to see what Mexico has argued. Mexico argues that in Resolute Force, that the tribunal explained that breaches of Articles 1102.3 and 1105.1 occur when the governmental conduct complained of occurs. Mexico believes that this conduct is towards the foreign investor. In fact, they say it. They say, an Article 1102 breach occurs when the treatment towards the claimant occurs. The claimant, us. Not when the treatment towards the comparator occurs. And they cite to Resolute Force versus Government of Canada, which says the breaches, again, that same quote above. And this was a case about a sale of a logging mill. There was the sale of the logging mill, which I will explain, was owned by a Canadian investor. But the tribunal stated in Resolute Force that in the present case, the essential acts alleged to constitute breaches of national treatment were completed by September 2012, 3 months before the critical date. It was in September 2012 that the sale of the Port Hawkesbury mill was finalized, along with associated promises of support. Essentially, the Canadian government had told a Canadian citizen that it would help it sell the mill. And that's what it described when it described claimant's national treatment claim. It said the claimants alleged that the Nova Scotia government implemented a series of measures to ensure that the Port Hawkesbury mill would have competitive advantages above any other paper producer, including Resolute, which is the claimant. So stating the obvious, the Port Hawkesbury mill belonged to a Canadian citizen. So, in the case, the Mexico cites to support that the act must be first to the claimant, it is actually the opposite. That tribunal held that the act that started the time for time bar purposes was the act towards the comparator, the Canadian citizen. Now let's go back and look in this case. What were the acts towards the 809 contract? In the 809 contract, the acta circunstanciata happened on April 9th, 2018. The acta de extinción happened on June 2018. And any act that happened towards us occurred on October 4th, 2018, or when we learned of the acta circunstanciata on September 2020. Our cutoff date is March 25th, 2018. Even if you went back to the original, very first act that took place towards us or the comparator, it happened after the cutoff date. There is no reasonable time bar argument for the national treatment claim. Now let's talk about the USMCA objections. Mexico makes similar objections under the USMCA. It says that we have not proven that we made investments into Mexico. The interesting part about the USMCA is the definition of investment is as broad or even broader than under NAFTA. It includes every asset that an investor owns or controls. Mexico also says that the 803 and the 804 contract are not still in effect, so therefore they do not fall under the scope of the USMCA. This is the same argument as before. The finiquitos for the 803 and the 804 contract have the same language as the 821 contract. They both say that the contracts stay into effect until the payment is made. The payment under the obligation of the finiquito. We haven't paid them anything for the 803 and 804 contract. Those contracts are still alive. Mexico also says that we have not made a qualifying investment dispute under the USMCA. And what that means is there's language in the USMCA that says a qualifying investment dispute needs something other than the written agreement itself. And this is interesting. A lot of Mexico's arguments come back to whether or not we've proven we sent things to Mexico, such as equipment. Again, we have. We have more than a written agreement. We didn't just sign a piece of paper and not perform, or we didn't just sign a piece of paper and nothing was sent to Mexico. We sent equipment, people, bonds. We made investments in Mexico. And you can see here the definition of the USMCA. It is broad. It means every asset that an investor owns or controls, directly or indirectly, that has the characteristics of an investment. Now let's talk about some of the more interesting arguments that Mexico makes. First, Mexico says that the actions of Pemex in this case are not attributable to Mexico. And to get there, they say that what the actions that Pemex took in this case, the actions that are complained of, were commercial in nature. They are actions that other companies, such as Finley or Exxon, could take. Well, let's talk about that. In this case, Mexico's national oil company, Pemex, entered into what was defined as a public contract for the satisfaction of the collective needs to explore for and exploit Mexico's hydrocarbons for the benefit of the Mexican state and to exercise an adjudicative function, which would be the administrative rescission. And if you look at the Pemex law, it says the state will carry out its activities through Pemex. That's clear. But besides the fact, let's just talk about what is complained of in this case. And we can use Mr. Asali's words, Mexico's expert. He says it exactly. First, to describe the contracts and the clauses that are within the contracts, Mr. Asali says this: the administrative contracts may and even must contain clauses that place the provider or contractor in a subordinate relationship with Pemex, so that the latter may guarantee the fulfillment of the state powers conferred to it. You see, in these contracts, Pemex is acting with the authority of the state power, Mexico. That is the direct definition of the USMCA and NAFTA. Now let's talk about administrative rescission. Mr. Asali says this. He says because of the administrative nature, the termination of the contracts entered into by Pemex is subject to a special regime, which, in accordance with the principles of public contracting set forth in the Article 134 of the Mexican Constitution, provides for a series of powers and procedures aimed at ensuring that the public interest prevails. And then the Pemex law allows for administrative rescission. So the exact action that followed the fake work order, the administrative rescission of the contract, was given to Pemex directly by Mexico. They were acting with authority, in this case, from Mexico. Mexico also argues that the procurement exception under the national treatment provision in NAFTA and the USMCA applies to this case. And to get to this point, Mexico essentially says that the procurement exception applies to every term of a contract that may have a procurement provision, which is essentially every contract that Pemex would give to an investor on a bid. But government procurement has its own chapter within the NAFTA and the USMCA, and it contains its own national treatment provision. And we did not bring a claim under that for one purpose. It's because the acts complained of here have nothing to do with the procurement. The acts complained of here were the administrative rescission of the contracts and the courts condoning that action. That has nothing to do with any definition of procurement you will find in any treaty or tribunal award. Now let's see what ADF has to say about what procurement is. Procurement refers to the obtaining by purchase by a governmental agency or entity of title to or possession of, for instance, goods, supplies, materials, and machinery. Procurement has nothing to do with the dissolution of a contract because you don't want to pay. It has nothing to do with the court condoning that action. It has to do with obtaining. The procurement exception does not apply to these contracts under NAFTA, nor does it apply under the USMCA. And the USMCA has a similar definitions. It's the process, they say. It's the process by which a government obtains the use of or requires goods or services or any combination thereof for governmental purposes. Again, the actions that we complain of in this case have nothing to do with the process of obtaining. Mexico has raised this argument, this same argument, in other tribunals in 1128 submissions, and we lay that out in our briefing. Those tribunals have also said that is one step too far. You cannot apply this exception to an entire contract or all the provisions under it. Now Mr. Browndorf is going to talk about Mexico's conduct in this arbitration.
Good morning. It is still morning. We've heard a lot about Mexico's actions thus far today in the fields of Chacantepec, in Pemex's offices, in Mexican courtrooms. And unfortunately, those actions have continued into this arbitration and are culminating in this room in Washington, D.C. today. Mexico has shown a blatant disregard for this process and this tribunal. And as a result, the opportunity for adverse inferences to be drawn has emerged, and claimants respectfully ask for them to be drawn, specifically with requests to Mexico's witnesses and its documentary evidence. To begin, Mexico tendered one fact witness. Mr. Lostenau is a lawyer at Pemex. He's also Mexico's party representative. Now, we look forward to hearing from Mr. Lostenau throughout the next few days. But we're not sure he will have much to say. In his first witness statement, he admits this. The 821 contract was not within his competence. We've shown you numerous individuals who have more relevant knowledge than Mr. Lostenau. Luis Gomez, David Ortiz, Epitacio Solis Fuentes, many others. One aspect Mr. Lostenau is intimately familiar with, however, is Mexico's document disclosure process. Mr. Bonfilio tasked him with responding to claimants' 18 document disclosure requests. These included administrative files for the contracts, budget and financial documents, work order documents, 821 rescission documents, 809 contract documents, and other compromises that were made with Mexican nationals. The tribunal ordered disclosure for the majority of these narrowly tailored and specific requests, and Mexico disclosed 154 documents in total. That number, along with the fox guarding the henhouse scenario that is present here, must be considered by the tribunal. Now, there are numerous examples of deficient disclosures. We will address the majority of them in our post-hearing brief, but today I'd like to walk through a few examples. Beginning with our budget document request, request number 6. As you can see, this is a multi-part request directly relevant to this arbitration. It asks for ledgers showing funds going in and out, original budgets, various other financially related documents. The tribunal unequivocally, you all unequivocally, ordered the production of these documents. Mexico disclosed 3 documents in total. They are each consolidated financial statements for Pemex for a period of 4 years. The inference should be drawn that the Mexican government allocated the budget outlined in each contract to Pemex, that being $48 million for the 803 contract, $55 million for the 804 contract, and $418 million for the 821 contract. Similar story with the 821 contract rescission request. The tribunal, I would point the tribunal's attention to subpart A, Pemex's decision to issue the July 31st, 2017 notice of rescission, including all internal analysis regarding the rescission. Again, the tribunal, the three of you, unequivocally ordered the disclosure of these documents. Now, Mr. Lostenau's May 8th memo, which Mr. Melsheimer discussed earlier, has various deficiencies on its face, the antecedentes. From that, we have not seen that document that preceded this. There should be an attachment to this document. We have not seen the attachment to that document. There was a meeting on May 3rd. Claimants and the tribunal are interested in what took place in that meeting on May 3rd that preceded this memo. It's important also to note that this is claimant's exhibit, not Mexico's. I would ask the question, would you all have seen this document if we did not obtain it? Again, I ask, who was in charge of this process? Mr. Lostenau. In its rejoinder, Mexico flouts the tribunal's order. You all wanted to see these documents, and instead, Mexico says, Mr. Lostenau and us have explained this, the context and meaning of this document. You are entitled to see the documents that preceded this and surround this and make your own interpretation to do so of what those documents mean. Next, we have compromises with Mexican nationals. An important part of any Article 1102 or Article 14.4 claim is showing comparators in like circumstances. Here, the tribunal, recognizing the significance of this request, ordered the production of these documents, so much so that it took time to discuss confidential information that may need to be redacted. Also, the tribunal noted that this request may be burdensome. The tribunal anticipated that there would be numerous documents related to this request. Mexico itself, in its counter memorial, said Pemex rescinded hundreds of contracts. Somewhere, there should be some documents related to Request 16 showing compromises with Mexican nationals. Instead, we got nothing. Mexico, in its rejoinder, brushed aside the tribunal's order, said claimant's request is a fishing expedition, and we're not giving any documents for that. The tribunal disagreed with a fishing expedition characterization. Instead, we found an instance of comparators in like circumstances through the 809 contract. Again, I would ask the tribunal, would you all have seen or known of the 809 contract and the companies Integradora and Zapata if claimants had not obtained this information? But Mexico has done this before in the national treatment context. In Feldman versus Mexico, the tribunal was appalled at the lack of documents available to it and ultimately asked itself the rhetorical question, if Mexico had evidence showing favorable or similar treatment to people in like circumstances, essentially showing that the claimant was not subject to unfavorable treatment, why did it not produce that information? Again, we would ask this tribunal to ask the same question here. Now, as I said, there are numerous other examples of adverse inferences we would request the tribunal to draw. We will address the majority of them in the post-hearing brief. However, I'd like to end with the statement that if there were ever a case or a particularly flagrant course of conduct that warranted adverse inferences being drawn, this is it. At this point, I'd like to turn over to Mr. Durman for some concluding remarks. Thank you.
I'm appreciative of the time, so I'll be very brief, and we can engage further when you have questions for us later in the day or during the course of the hearing. Obviously, we have very, very compelling facts here. I think it's going to be fairly easy for you to determine that Mexico was looking to frustrate the contract and to rescind it. And they did it in a very, very clumsy way. And their fingerprints were on it, but it took an incredible amount of investigation on our part to put the puzzle together, because we did not get cooperation on this document request during the course of this proceeding, which was problematic for you and for us. No doubt you have to find fair and equitable treatment. Was not extended to Jim and to Luis. If you were Jim and Luis and you signed contracts, $45 million on 803, $55 million on 804, $418.3 million on 821, and you then did everything possible to meet the requirements of putting the machinery, the equipment, the supplies, and the people in country to fully perform those contracts. And you were confronted with this timeline. You signed the agreement on the 821 contract in February of 2014. Work starts. Go back to the chart and see how the precipitous fall of oil is about to happen, right? We went from $100 oil to $26 oil during the 2014-2016 period. That was a dramatic fall in the price of oil. Jim and Luis and their respective companies did not take price risk. That was the risk that Pemex and Mexico took. If the price of oil fell, they don't walk away from the contract. The rescission of these type of agreements, and specifically in the 821 contract, is an extraordinary event. It's a draconian event, and it doesn't happen because you miss one fake work order. It doesn't, and it didn't here. Work starts, and then work stops in November, and you have no work for 108 days. So do the math. There was a $418 million contract. This was just one of the three, $418 million that you guaranteed performance. It was a provision in the contract. Pemex could have requested additional work, and that would be negotiated with you, but you guaranteed performance $418.3 million. And you spent the requisite funds and put together the material, the equipment, and the personnel to fulfill that obligation. And they stopped issuing work orders. 108 days, no work orders. Machinery is sitting there. People are sitting around waiting for the work order. Jim and Luis will talk to you about the numbers of people they had on the project. There were a lot of people here. This was an army of people waiting to do this work. There were multiple rigs that need significant numbers of people. If you take the 821 contract, which is 1,402 days, that's the length of the contract, and you divide it by 41,300,000, you're approaching $300,000 a day in expected revenue. Not every day you're going to get that revenue, but it's like a lawyer who doesn't bill for a few weeks. Those hours don't go away. They just get added on to the balance of the year. And here, there was an expectation of a revenue stream over the course of the contract, of the course of 1,402 days, on average, just shy of $300,000. And for 108 days, you do nothing. What are you going to do? They don't leave. They stay there. They keep all these people employed and the equipment just sitting there with weeds growing around it. And a little work starts happening. And in Pemex's analysis, 11% of the work required under the 821 contract was actually subject to work orders. 11%. The work starts and then it stops for 98 days. That's 98 days where you have more than 100 people staring at you with nothing to do. But they don't leave. They actually stay there and they complain, they try to talk to Pemex. Work starts, a little bit of work. Remember, the entirety of the work is 11% of the $418 million. Work starts and then it ends. 105 days of sitting around watching your equipment and your people do nothing. Now, price of oil, it's really depressed. It's not our risk. It's not our risk. It's their risk. So what do? They file a lawsuit in April of 2006. They're desperate. What would you do? You would expect that you file a lawsuit, either Pemex's attention will be grabbed and they will do something, or the courts will help you. Anyway, retribution happens, retaliation happens. We have 210 days. Okay, now it's like everyone knows, look how many days we have, almost a year. 105 plus 210. Since we know no work. Everyone knows that the lack of work, people are leaving, they're laying off the people, they have certain labor issues they have to deal with. This is a bloody disaster. And then you get a work order. It's a fake work order, right? I mean, if they had someone that could testify that that work order was real, we would see them. You know who we're seeing? We're seeing a lawyer that you will hear from. You can ask them about that work order. And I would encourage you, you should ask a lot about that work order. They issue a fake work order. And they know it, because you will hear testimony and there's evidence that Pemex officials at senior levels tell them it was a fake work order. And that is the basis of their case, this fake work order. If you wanted to rescind the contract, you could have done a better job at rescinding. 15R is very specific in the contract. It says if you have in 15R 15 unfulfilled work orders, then Pemex has the right to rescind. Well, why is that? This contract doesn't just let you rescind for no reason. It has first penalty provisions. Look at the contract. It's not complicated. The contract says if you don't comply, there's a penalty. And then what we'll do is when you get the invoice, we will penalize you for the penalties. They could have done that. Mr. Melsheimer showed you a slide. He said, in 6.6, there's a provision. It says if you have a work order that's unfulfilled, you pay a penalty. The penalty is $17,500 a day. You pay that penalty. If after 15 days you haven't done the work, after 15 days you pay a fine of $262,000. That's the way the contract works. You pay a penalty of $262,000. Then Pemex has the right to either reissue the work order to you or to someone else to do the work. Fine, you didn't fulfill the work, there's a penalty, and then they can reissue the work order to someone else to do the work. If you jump ahead to rescission, that's the situation we have today. You jump ahead to rescission in Article 15R, if you have 15 of those, 15 unfulfilled work orders, you are really bad. You have really not conducted your operations in a manner that's acceptable under the contract, the parties agreed if you had 15 unfulfilled work orders, Pemex had the right to rescind. But that rescission was qualified by the usual, and in this case, the included cure provision and good faith. There was no cure. You had the right to kind of fix the problem. Before you rescind a $418 million contract, the other party has the right to cure. But this case, we have one work order, not 15. We don't have the requisite requirements. And they rescinded the contract with that one work order. Now, you say, oh, okay, well, that cannot happen. The judiciary and the legal system will protect you. Well, it didn't. And then in 2018, we realized, as a consequence of the meetings that you heard about earlier, that we were not going to get due process in Mexico. We didn't get due process on the 803 contracts. We didn't get due process on the 804 contracts. And on 821, we heard that the judge ruled against us, and we were lost. The contract was going to be rescinded. And the judicial process, the administrative process, was going to be used to reinforce the decisions that Pemex made. That can't be the result. This is why we have treaties like NAFTA and the USMCA, to avoid this very situation. If you were to accept and condone the behavior, you will be creating a map to allow others to be abused as the claimants in this case. Given the fact that that's probably my end of my time, I will take my leave now.
Many thanks, Mr. Derman. I think you were right on time because there had been a 10-minute break, so I think there's a washout. So now we take a 15-minute coffee break, and then we resume. Sorry, we are at 12:15. Yes.
Una
Sorry.
cuestión de logística, señor
Yes,
presidente.
A housekeeping question, Chair. I understand that according to today's schedule, we're now going to take a break. After that, that will all be time for the respondent's opening, or is it anticipated that there will be lunch, or will lunch be not until 2:30? And I simply ask to coordinate it because I tell you to be totally transparent, we're still putting some documents, particularly the presentation, but I want to be clear on the logistics.
Break for the stenographers, so not got the 2 full hours on a continuous basis. So let's say 90 minutes, and then a short break, and then we continue all the way up to lunch. Then what would you propose for us to advance the lunch so that you can continue the opening statement after lunch?
Esa podría ser una propuesta.
So that could be one proposal if the tribunal agrees with it. Otherwise, if you believe that we should proceed as per the agenda, then we can speed up the printing that we're doing, and I would estimate that it could be ready in 20 minutes. And we can give an update to the Secretary of the Tribunal as it goes.
20 minutes after lunch. Would that be okay for claimants to have the rebuttal? Sorry, you cannot produce at this time this presentation.
Las impresiones a color todavía no están.
The color printouts are not yet ready, but we can send them immediately.
You have the written presentation you can present on the screen.
Por supuesto.
Of course.
Claro.
Yes, probably the best, as my colleague says, is that you start with a video presentation, with a, PowerPoint presentation, and later on you distribute the written document, and in the meantime we'll take notes in our notebooks, unless there is any problem that.
I'm having some problems with the transcription devices, and so.
Could you press the button, please?
Oh, I'm sorry. Just, we're having some trouble with the transcription devices, so I wonder if we could take a minute to get those fixed.
Yeah, right now, you mean?
Yeah, the monitors they're just not working.
Okay, so let's break. Well, anyway, we are going to break for 15 minutes, and then you can fix that during that time.
Y tenga la seguridad, señor.
And rest assured, Chair, that as soon as the printed versions are ready, we'll distribute them to everyone immediately.
At is 2:20, 2:30. Sorry, I'm lost because here at 12:35, I think.
I'm sorry, I'm just confused. Maybe I'm just tired. Are we going to get a copy of Mexico's opening now and then take a break while it's being printed, or I thought it was just an issue of printing?
Yes, we're going to take the break right now, and Mexico will be distributing its written document sometime at the beginning.
Yeah, but
yes, well, actually, there is a thing that claimants are entitled to review a priori the document, but that would require to make an additional break. So if you are ready to stay here in the room until 6 o'clock, that's fine. So there's nothing wrong if we extend a bit that break so that you can review the document.
yeah, we're happy to receive an email right now with their presentation.
Eso es lo que haremos.
Okay, wonderful. So you get the email, we break for 15 minutes, and then you start before we get the physical document printed. Okay.
Es correcto.
So I think we are ready to resume the session, friends and everybody. Mr. Bonfilio, you were suggesting to have a 1 hour expose and a break? Or because the agenda is for you to go the full 2 hours and have a sort of Spanish time lunch. For me, it's fine. So, but do you insist in having just 1 hour and then another one? Because that would raise the question that the rebuttal would have to take place right after the end of the opening statement, and I don't know whether that's the best for claimants. So, unless you decide otherwise, we should stick probably to the 2 hours in one single go, with a break for stenographers, definitely. Unless you are generous enough but I think it's better to have the full 2 hours with a minor break in between. Okay, so Mr.
We agree with you.
Okay.
De acuerdo.
Mr. Bonfilio, you.
We agree, Mr. President. Thank you very much, Mr. President. Just one moment, just to confirm that we can see the presentation on the screen. Good morning, Mr. President, members of the tribunal, members of ICSID, and representatives of claimants. On behalf of the delegation of Mexico, it is a privilege for us to be here before this tribunal to present Mexico's position on the main items that are going to be submitted in this arbitration, and also to provide a simplified view to the tribunal of the core aspects of this case, so that the tribunal may reach the conclusion that the dispute commenced by Finley Resources, MWS Management and Price, is not within the jurisdiction of the tribunal, or that the tribunal may determine that the case has no merit. We will begin by trying to make clear who the claimants are. Finley Resources and Price started this arbitration on their own behalf and in the representation of Drake Mesa under NAFTA. This in connection with events related to a contract that we have been calling Contract A21, which was entered into in February 2014 with Pemex Exploración y Producción, a subsidiary company of Petróleos Mexicanos. Essentially, these companies claim that there was a violation of the minimum standard of treatment under Article 1105 of NAFTA because of an alleged repudiation, so have they said, of Contract A21 by Pemex Exploración, and they also allege a denial of justice by Mexican courts. This allegedly related to litigation under Contract A21. MWS Management Price, as a representative of Bissell, a Mexican company who's also a claimant in this arbitration, well, they submitted their claims under 14E of USMCA because of events related to contracts 803 and 804 that were also entered into in February 2012 and March 2013 with PEP. Unlike the case commenced under NAFTA, the arbitration commenced by MWS, Price, and Bissell. In that case, they only claim that there was denial of justice. The claimants also say that the national treatment principle was violated under both treaties because there was apparently discriminatory treatment, they say, because they consider that two Mexican companies, apparently controlled by Mexican nationals, received preferential treatment by PEP. We are going to go in depth on these issues later on. There's certain basic premises in this arbitration that we feel that the tribunal has to bear in mind. First, Pemex is one more participant of the energy market in Mexico and internationally. These contracts were not entered into via a regulatory or administrative role of the company. These three contracts had one single purpose, which was to provide services to PEP. The claimants are companies and that provide services to the energy sector participants. You are going to hear members of the tribunal mention of Pemex and PEP, but PEP was the company that entered into the contracts with the claimants. The contracts were not even signed with Pemex. But the most important thing is that neither Pemex nor PEP are organs of the state. These are productive enterprises of the Mexican state, and their purpose is to create an economic value. Second, this is the second premise, the contracts 803 and 804 terminated when they were closed and when the finiquito was formalized. You're going to hear a lot about this word, finiquito, in the next few days. But contract 821 was rescinded by PEP because of contractual breaches by claimants. Evidence of these breaches is clear, and it speaks for itself. Third, complex litigation cannot be equated to a denial of justice. The claimants committed a number of omissions and acted negligently during the civil administrative lawsuits that they commenced against PEP, and they also minimized the impact of the COVID-19 pandemic on the roles of the judiciary of Mexico and of the Federal Court of Administrative Justice. Taking this into account, the reality is that these cases were decided during reasonable periods of time, and the claimants were able to exercise their rights before these courts, and simply claimants' claims do not reach the necessary threshold to show that there was a denial of justice. The claimants also put to Mexican tribunals these same practically claims that are submitted to this arbitral tribunal. This tribunal cannot act as an appeals court. The fact that the claimants do not agree with the decisions entered by Mexican courts, that cannot amount to a violation of the provisions of USMCA or NAFTA. From the beginning of this arbitration, the claimants have been very unclear about the facts and about their legal position throughout this arbitration, and we're going to divide our presentation into three different sections. First, we're going to talk about jurisdiction. During this arbitration, we have read and heard criticisms by the claimants in connection with a number of objections put by Mexico in this arbitration. But the truth of the matter, members of the tribunal, is that the objections that we have placed are the ones that are usually put in investment arbitrations when a case is deficient. We have been forced to bring 14 jurisdictional objections. This is a considerable amount, of course, but it has a reason. Basically, claimants unilaterally consolidated 3 arbitrations into one. Also, the manner in which the case was presented by the claimants has been so deficient that it shows that this is completely without the jurisdiction of the tribunal. We're going to talk about the most relevant facts of this case. That will be our second section. In our third section, we're going to explain the position of Mexico in connection with the lack of attribution by Pemex, the deficiencies in connection with the national treatment claims, and we are going to talk about the fact that there was no violation to the minimum standard of treatment principle. We have heard very patiently the accusations by claimants against Pemex, its executives, against the Mexican state, delegates, and also against individuals that are foreign to this arbitration. We are not going to behave in such a manner. Members of the tribunal, the reality is that claimants have been unable to show that the tribunal has jurisdiction to decide this case. International tribunals, such as this one, must be incredibly cautious when analyzing the existence of jurisdiction, simply because the exercise of jurisdiction by a tribunal in connection with a dispute in which the state has not provided its consent, this is a great impairment to its sovereignty. That is why investment tribunals must determine their jurisdiction in a very rigid and conclusive manner. And that is why we would like to explain our position to the tribunal in connection with the jurisdictional aspects of this case. Very rarely has Mexico faced claimants that have not taken due care when presenting basic elements that show the jurisdiction of the tribunal, and this is one of those cases. The respondent had to submit a number of jurisdictional objections. Some of them apply to the case as a whole, and some to specific cases. For example, the USMCA case and the NAFTA case. I'm going to talk about a jurisdictional objection that applies to both cases. The tribunal has no jurisdiction to decide a case that was self-consolidated, quote unquote, under different treaties. Let us recall that the claimants submitted unduly claims under 14C and 14E of USMCA. Neither Mexico, however, nor the U.S. provided their consent to submit claims to arbitration under 14C when they could have been brought under Annex 14E. Suppose in arguendo that one would be able to submit claims under both treaties. The claimants' claims are based on very different disputes. This is important because only one controversy, one investment controversy can be decided upon in one arbitration, and this is in the language of Article 14E2 of USMCA. The matter that the tribunal has to decide is whether the different factual allegations submitted by Finley, MWS, and Price can be considered as a single dispute. We consider that the answer clearly in this case is no. For a single dispute to exist, the interest of all of the claimants must be identical in all aspects. For example, in Matthias Cook v. Spain, the tribunal said that interests are identical when the claimants have invested in the same project or in related projects. They have made their investments on the basis of the same terms and statements, and when they bring their claims on the basis of the same legal arguments, and they do so against the same respondent. In this case, the interests of Finley, MWS, and Price are not identical. Two of the three claimants submit claims related to Contracts 803 and 804 under Annex 14E of USMCA, while Finley and Price submit claims related to another contract, Contract 821, and they do so under NAFTA, a totally different treaty. The evidence shows as well that we're dealing with three different contracts related to different projects. Contract 803, for example, entailed work on wells that had been already drilled. 804 had a purpose, which was to drill completely new wells. We understand that Contract 821 had a purpose, which was to conduct fracking work. Another situation to consider is that the terms of each of these contracts were different. 803, for example, had a duration of 22 months, 804, 6 months, and 821, a little under 4 years. And that's not all. The claims on minimum standard of treatment by Finley and Price are relying on an alleged plan by Pemex to terminate 821 and to call on the Dorama bond. They also allege a supposed denial of justice, but MWS and Price allege a violation of the MST because of the alleged delay by the Mexican judiciary when issuing decisions related to lawsuits for 803 and 804. So what happens here is that these things are completely deficient, and there was a self-consolidation by claimants. I'm going to talk about 6 jurisdictional objections under the NAFTA. First, the tribunal lacks jurisdiction to decide in accordance with NAFTA claims related to Contract 821. The parties agree, apparently, that 1121 of NAFTA is applicable to the claims under Annex 14C of USMCA. The purpose of this provision is to prevent a claimant to allege violations under Article 11 before a Mexican court and then to do the same thing before an arbitration tribunal. So this is very similar to a fork-in-the-road provision. We have shown in this arbitration that since January 2019, before this arbitration begun, Drake Finley alleged violations to Article 1105 of NAFTA, and it did so before Mexican courts. First, via the Direct Amparo 74/2019, and later on during the appeal for review, which was number 1865/2020, that was put to the Supreme Court of Justice of Mexico. In 2 occasions, the claimants claimed before Mexican courts that there were alleged violations to 1105 of NAFTA. As we have explained during our arbitration, it doesn't matter that the claims under 1105 put to the Mexican tribunals have not prospered. The important thing here is that the clear language of 1120.1 applies simply because Finley brought these arguments. As if this were not enough, we have to recall that on 30 April 2021, the claimants sent to ICSID a note where they basically admitted that they relied on NAFTA for their claims, and these claims were submitted effectively to Mexican courts. So the claimants seek to take importance out of this situation, and the evident thing is that there was the application of 1120.1 of NAFTA, and consequently the tribunal has to determine that it lacks jurisdiction to deal with this arbitration. Also, the second objection under NAFTA is that the tribunal lacks jurisdiction to decide this case, the case presented by Drake Finley, because the claimants did not submit their waiver and consent, which is a requirement under 1121. So This article establishes conditions precedent to submit an arbitration claim. If the claim is submitted under 1116 and 1117 of NAFTA, the company in its own name or in the name of another company controlled by it or owned by it must waive its right to commence or continue any judicial or administrative case against the allegedly violation measure, except where those procedures, when it is asking for a suspension of a decision. Article 1121.3 is very clear, and there was no acceptance by respondent to allow for this late presentation. So the conditions precedent did not happen. The ones under 1121, which is on the screen. Other NAFTA tribunals have allowed for this. Waste Management, for example, said that if the requirements of 1121 are not met, there is no consent for a dispute to be resolved. And this principle was also followed by the tribunal in Detroit International v. Canada. So a lack of consent and a lack of waiver cannot be corrected throughout an arbitration. This was confirmed by the KBR v. Mexico Tribunal. As a result of this objection, the pertinent thing would be for the tribunal to conclude that there is no consent by Mexico to allow for claims to be brought by Drake Finley. The third NAFTA objection. This tribunal does not have ratione temporis jurisdiction. Articles 1116 and 1117 of NAFTA on the screen establish that no claims may be presented if more than 3 years have elapsed from the date on which the investor, whether it be an entity or an individual, gained knowledge for the first time of the alleged violation, including knowledge of damage or loss suffered. The parties agree that the critical date for purposes of the statute of limitations is 25 March 2018. This is a very important date. Investment tribunals have said very clearly that the statute of limitations is clear, it is rigid, it cannot be suspended, extended, or it cannot be subject to any other requirement. So, knowledge is acquired with the first appreciation of the damage, and the claims by claimants related to A21 and submitted under NAFTA are time-barred, and there are 3 situations that show this. First, the evidence in this arbitration shows that since November 2016, the claimants had the knowledge of this and that allegedly Pemex was going to try to rescind A21. But then in August 2016, rather, in April 2016, Drake Finley started proceeding 200 2016 against PEP, and it claimed millions of dollars. In the claimant's reply, they tried to put a new theory according to which the alleged scheme by Pemex to repudiate A21 materialized because there was a breach that occurred in October 2018. But there is no evidence on this.
Segundo aspecto,
The second aspect, in connection with the statute of limitations, claimants hold that there was denial of justice in October 2018 when the Administrative Tribunal issued a decision in favor of PEP. This is a lawsuit that we have called the annulment proceeding of 2017, but the selection of this date by claimants is arbitrary. It should be recalled that starting in 2016, claimants were litigating aspects related to Contract 821, and the claimants, as a matter of fact, have not been able to explain why they were allegedly denied justice on October 4th, 2018. The third aspect in connection with the statute of limitations, the national treatment claim is also time-barred because the alleged discriminatory measures against the claimants took place before the critical date. According to claimants, and we were able to hear this during their presentation, this violation took place in April 2018 when Pemex supposedly reached an agreement with other service providers in the oil field that were controlled by Mexicans. But seemingly, the claimants are forgetting that Article 1102 of NAFTA focuses on the measures adopted towards the investor, that is a claimant, rather than third parties. Therefore, this alleged discriminatory treatment that is being claimed by claimants took place much before the critical date. The fact is that there are no doubt that the 3-year period under NAFTA started to run in 2016 based on the data that I am mentioning, and also the conclusion that the tribunal can easily reach to is that they lack jurisdiction rationale temporis. Fourth, the tribunal has no jurisdiction to decide on aspects related to Contract 821. Various tribunals under NAFTA have clearly concluded that they have no jurisdiction to decide on contract disputes, as we saw in Waste Management 2, whereby the tribunal concluded in all clarity that, contrary to other investment treaties, Chapter 11 under the NAFTA does not grant jurisdiction to solve contract breaches. Therefore, the alleged plan Pemex had to rescind Contract 821 and enforce the Dorama bond is a contract claim that is disguised as a claim under 1105 of NAFTA. We also state that it is not true that Pemex, much less the Mexican state, has orchestrated a plan to terminate Contract 821, but this claim is clearly a contractual claim, and claimants were unable to show whether there were measures that were sufficiently shocking or egregious to conclude that there was a breach of Article 1105 under NAFTA. In addition to this, Contract 821 is not an existing investment. Under Annex 14C, we can see it on the screen, and it is very important for me, for Mexico, to guide you in connection with some of these dates. Contract 821 was signed in February 2014, whereby USMCA entered into force on July 1st, 2020. That is, it was in the USMCA was finalized August 2017. That is almost 3 years before the entrance into force of USMCA, and then it cannot be considered as an existing investment. All of the investments that are linked to this contract should be addressed as just one investment to determine whether claimants had an existing investment, including real estate, tangible real estate, or intangible real estate. or at any rate, or intangible goods, or any investment in connection with 821 also terminated at the time of its termination, that is August 2017. The issue of the Dorama bond is extremely problematic under NAFTA and the Exit Convention. This takes me to the fifth jurisdictional objection. The parties agree that the adequate standard to determine whether the Dorama bond is an investment under the Exit Convention is through what we know as the Salini test. And to that end, some factors need to be proven. First, whether it is a contribution. Second, whether it has a duration. Third, if it yields an investment risk. This is extremely important. And fourth, if there is or it is a contribution to the economic development of the host state, in this case, Mexico. But these elements are not met in this case. The Dorama bond did not lead to a contribution in Mexico. For a contribution to exist, we need to have the search for an economic operation that creates value. The Dorama bond is just a commercial bond intended to guarantee compliance with some obligations agreed under a service contract. In clearer terms, for the benefit of the tribunal, the object of the Dorama bond was not to create economic value, rather to guarantee the fulfillment of contract obligations. It is that simple. The Dorama bond did not generate a risk, and it was not intended to generate any gains to favor claimants. Various investment tribunals have indicated that this criterion refers to investment risks and not merely, as claimants intend, commercial risks. The Dorama bond at the most implied a commercial risk subject to compliance with the service contract, and clearly claimants knew that given a breach of contract 821, PEP could claim enforcement. Claimants accepted to incur in this commercial risk at the time of signing their contract with PEP, that is contract 821, and this contract right could be enforced at any time. The Dorama bond did not create a benefit for the Mexican state, much less did it contribute to increasing the hydrocarbon production. The only object was to guarantee contract obligations. With this in mind, the tribunal will be able to conclude, rather, that the Dorama bond is not an investment under Article 1139 of NAFTA or under Exit Convention Article 25. Sixth and final objection under NAFTA. The tribunal lacks jurisdiction because no investment have been proven as existing under Article 1139 of NAFTA. If an investor does not establish the critical facts to show the jurisdiction of the tribunal, being one of them the existence of a covered investment, the tribunal should easily conclude that they do not have jurisdiction. 6 aspects related to this sixth jurisdictional objection are relevant to the tribunal. First, Contract 821 was signed in February 2014 by Drake Finley as contractor and by Finley and Drake Mesa as parties that were also part of this contract. Drake Finley is also a Mexican corporation as signees of this contract, and there was no waiver that was presented together with the request for arbitration. Therefore, they cannot present any claims under their name. Second, there is no evidence to show that claimants themselves have carried out any investment. In the reply memorial, the claimants indicated that the rigs and the equipment were obtained by an American company that was completely different, called Drake Mesa LAC. but it is very important to mention that Drake Mesa LLC is not a claimant in this arbitration, and if this was the entity that carried out the investment, this company was compelled to present their own claim, but they didn't do so. Once again, claimants mix the discussion of their alleged investments under three different claims that are completely separated under two different treaties. The truth is that if they were attempting to find some sort of confusion and try to overcome these jurisdictional hurdles. The third aspect, there is no clarity as to the purchase of the equipment or the transfer of the property to the alleged companies in this arbitration, and the claimants are hereby presenting their claims. There is no evidence that is sufficient to show that the land that has been known as the yard has been purchased as an obligation under the three contracts. The truth is that the witnesses of claimant and claimant themselves indicate that the land, the yard, was bought by Baku Exploración y Producción, which is not a claimant investor in this case, and claimants have not presented any claim on their behalf. The fourth aspect to bear in mind.
Las demandantes
If the claimants hold that their shareholding with Drake Mesa are their investment, it is sufficient for us to mention that there is no evidence that the property or control of these companies has been impacted in any way. And if the claimants hold that Drake Field is the owner of an investment, we should recall that this goes beyond the application of this arbitration because their consent or their waiver were not presented together with the request for arbitration. Fifth, Contract 821 is a service contract, and it is excluded from the definition of investment under 1139 of the NAFTA, and this article clearly excludes as investment any pecuniary claims or claims to money that arise solely from service contracts, and they call themselves service providers, and they have classified the three contracts as service contracts.
Demandantes afirman estar en circunstancias.
Claimants ascertain that they are also in a relationship with these companies, and they clearly indicate in joint mining that the existence of a capital commitment
asociado fuera automático.
Did not entail that the associated contract was any sort of investment that was subject to the protection under the treaty.
Sostuvo que
And this tribunal also held that whenever a contract also involves additional aspects, such activities such as services, this does not render it into an investment. The same criterion has been also implemented by investment treaties under Chapter 11 of NAFTA. The sixth aspect that is related to this objection under NAFTA, the Dorama bond is not an investment under the Exit Convention, but it is not either an investment under 1139 of NAFTA. The commercial guarantees that service providers should grant under various contracts, such as Contract 821, do not give rise to substantive rights to the party that is granting the bond. The Dorama bond is not an investment, does not qualify as an investment because there is no interest derived from it. The claimant has no interest in it, and then this is supported by White Industries, by the case of White Industries, and Joy Mining v. Egypt. So if the tribunal bears in mind these six objections, they will be in a position to conclude that they have no jurisdiction. Now, I will explain the reasons why the tribunal does not have jurisdiction to solve to decide the case presented under the MCA. The same situation that we had with the NAFTA, we have with the MCA. And for this reason, the respondent needs to present 5 objections under this treaty. The first objection
En torno a que los contratos 803 y
has to do with the fact that contracts 803 and 804 are not protected investments. Chapter 14 on the screen only applies to what is known as a covered investment, that is, an investment that existed from the moment that the USMCA entered into force or that it was established or later on expanded. The issue to be solved by this tribunal is whether the claimants had investments in Mexico that existed as of July 1st, 2020. The answer is no. 803 and 804, as we can see in this timeline, came to an end on their own terms and stopped existing before the entry into force of the USMCA. Contract 803 came to an end in February 2015, and 804 came to an end in April 2015. They did not exist as of by 2020, and also they did not exist by July 1st, 2020, and also claimants have not proven to have any investments by then. The second objection is that the claimants did not prove that they had an investment under 14.1 of the MCA. This article under the USMCA has a limited list of what is to be understood as an investment, but instead of clearly identifying the investments that fit this definition, the claimants merge their claims by saying that they imported equipment, they hired employees, and that they also acquired real property and other property. And also, in their opinion, all of this should be considered an investment, as well as the 2 guarantees that they offered. And contracts 821, 803, and 804 were signed by MWS Bissell, and there is no proof that MWS and Bissell were the owners of some of the real property or equipment. Baku, according to claimants, was the owner of the real property, but Baku is not an investor and is not a claimant in this arbitration. The documents that on November 20th, 2023 were presented by authorization of the tribunal into this case on the record by claimants do not solve this problem. Contracts 803 and 804, let us remember, are contracts for services, and their nature is not included as part of an investment under the USMCA. The property interest by claimants on Bissell has not been disrupted by actions of the Mexican government. And as we see it with the Dorama bond, the bonds granted under 803 and 804 are mere commercial guarantees that do not meet the Cellini test. The third objection under the USMCA, the tribunal is not here before a dispute regarding a protected investment. So for any claim to be presented in connection with a minimum standard of treatment, first, the claimant needs to prove that there is a covered or a qualified investment dispute. And any company, such as in this case MWS, Price, or Bissell, they should have proven that they were parties to a contract that was covered, a covered government contract, but they failed to do so. The fourth objection under the USMCA. The tribunal lacks jurisdiction because most of the claims by claimants are beyond the application of the USMCA. On the screen, you will see Article 14.2.3 of the USMCA, except for what is stated at 14C, a different annex. Article 14 does not bind a party to the USMCA to acts or facts that took place before the entry into force of the treaty. In other words, there could not be any claim under the USMCA for any measures that took place before July 1st, 2020. That clear. It is that clear. We should recall that 804 came to an end in April 2015, and 803 came to an end in February 2015. That is more than 3 years before the entry into force of USMCA. This is also very similar to NAFTA. A national treatment claim is focused on measures towards the investor, the claimant investor, rather than third parties, as the claimants are alleging in connection with Zapata and the consolidating company. But leaving this behind, the agreement signed by PEP and Zapata Integradora was signed in April 2018. That is a long time before the entry into force of the USMCA. The third aspect in connection with this jurisdictional objection, the last material event related to the proceedings from contracts 803 and 804 was the suspension of work by the Judiciary of the Federation, which took place on March 20th, 2020 due to the COVID-19 pandemic. After this date, there were no events that could be considered as events that were a denial of justice for the disputes in connection with both contracts. These are some clear examples that show that the actions claimed under the USMCA took place before July 1st, 2020, and therefore the tribunal could easily conclude that they lack jurisdiction. Finally, the fifth objection under USMCA. The tribunal lacks jurisdiction because the measures are time-barred. The USMCA reflected went back to the drafting that we saw in NAFTA in connection with the term to present claims, and this is a serious consequence for claimants since the critical date is March 25th, 2018. We should indicate that Bissell and MSW started in October 15, the civil lawsuit that we have called in this arbitration 17-2015, in which they claim against PEP millions under contract 803. And briefly after that, December 2015, the claimants also initiated under 120 of 2015 another lawsuit under contract 804 against PEP for amounts that equal millions. So the claimants knew of an alleged violation or damage before the critical date established under USMCA. To attempt to claim denial of justice, claimants indicate that disputes in connection with both contracts had some sort of considerable significant delay in an attempt to deny this the period of the time bar under the statute of limitations. But these delays, according to claimants, took place in April and June 2018, according to claimants. But once again, the selection of these dates is arbitrary because it is just an attempt to exceed the critical date under this contract. And also everything that has to do with national treatment under USMCA, as we see with NAFTA, are extemporaneous because of the reasons that we just mentioned. to conclude these 5 objections or defenses that we have presented under USMCA, the tribunal should declare that they lack jurisdiction to decide on the case presented by Price and MWS on behalf of Bissell, but in spite of all of these vices, jurisdictional vices, we will refer to the relevant facts in this arbitration, and to that end, I will give the floor to my colleague, Rafael Arteaga. Mr. President, before I start, I don't know if you'd like to have the break now. My first portion of the presentation will take about 25 minutes.
1 hour, so I think it's fine if we make now a brief break for, say, 10 minutes, and then we have the second hour for respondent.
Perfect.
So it's 27, so we'll resume at 37. Well, I hope the stenographers could relax for a while. and we resume, and Mr. Arteaga has the floor.
Muchas gracias, señor presidente.
Thank you very much, Chair. Before getting into the detail of each of the contracts, it's important to understand their context. Those contracts were entered into when there was a heavy demand for oil services because of the high oil prices, which were more than $100 per barrel in 2014. Crisis began in oil prices internationally, which brought about very negative impacts for energy prices, including Pemex. For example, the prices for the Mexican mix fell from almost $100 per barrel to just $23 per barrel in early 2016. This clearly brought about liquidity problems. In order to address the international crisis, the Board of Directors of Pemex adopted several measures, including adjusting the budget of Pemex and its subsidiaries in order to reduce expenditures in hydrocarbons activities. Plus, Pemex had to draw up adjustment plans, modify its investment portfolio, and it even had to halt the production at wells whose extraction cost was above $25 per barrel. Clearly, it was not reasonable to think that the contracts would last indefinitely or would remain unchanged. But once again, this was due to the international crisis in the price of oil. The services to be provided under the three contracts would unfold in a project known as Chicontepec, which, according to the claimants themselves, has complex geology and posed technological and financial challenges for extracting oil. The complexity of the project is well recognized. Finally, it's important to note that the three contracts were entered into in keeping with the so-called 2008 Pemex law. This law established that all contracts entered into by Pemex and its subsidiary companies, such as PEP, should have certain terms and conditions that would enable them to create, modify, or extinguish legal situations without need to turn to courts or arbitration, which I will detail in a few moments. We'll begin by explaining Contract 821. We should recall that the claims by Finley, Price, and Drake Mesa under NAFTA are based on alleged violations related to supposed repudiation of Contract 821, supposed plan orchestrated by Pemex to terminate this contract, and execution of the Dorama bond, and supposed denial of justice by the Mexican courts and a supposed differentiated treatment with respect to other service providers. It should be clear that Contract 821 was a services delivery contract and nothing more. The claimants seek to give the impression that Contract 821 was executed due to its alleged meetings with various former officials of Pemex. That was not the case. The reality is that Contract 821 was the result of an international public tender in which Finley, and Drake Mesa participated, along with many other companies who sought to be service providers for PEP. Our position is that this tribunal does not have jurisdiction to hear contractual claims. Yet, the claimant's arguments on Contract 821 and its erroneous interpretation of its clauses requires that we clarify a few points. First, based on some screenshots from an internal Pemex system and the procedure for calling the Dorama bond, the claimants seek to allege that they had expectations that PEP would exercise the maximum amount of the contract. This is simply incorrect. Contract 821 speaks for itself. Clause 5 of the contract expressly established the minimum and maximum budget that PEP could have for seeking the performance of work under Contract 821. Very simply and clearly, this clause establishes that PEP was not obligated to use the maximum amount. Mr. Asali has explained the situation in his reports, and the respondent invites the tribunal to analyze them carefully. Bearing this in mind, we'll now analyze the contracts here. Under the three contracts, the work was carried out under what are called work orders, which are simply instructions that PEP would issue in writing to do certain work and specifying their scope and the period for their execution. During the time of execution of Contract 821, the international crisis in oil prices, which we've mentioned earlier, began to materialize. To address this crisis, for certain periods of time, PEP would suspend drilling and termination activities due to the lack of resources and the actions that Pemex had to take. Pemex also had to reach agreement with the providers on expanding payment periods. This was not done unilaterally, as is falsely alleged by the claimants, but rather through modifying agreements such as the one signed in 2016. In all, under Contract 821, 28 work orders were issued, 26 of which were carried out, one was canceled, and one other was breached by Drake Finley, went unfulfilled. This leads me to talk about its rescission. Despite everything we've heard from the claimants, the reality is that it's not been possible to refute the fact that they failed to carry out Contract 821. As I indicated, Contract 821 was entered into in keeping with the 2008 Pemex law, which required that Pemex include in all of its contracts certain clauses, including the clause on rescission. The particularity of this provision is that Pemex could extinguish legal situations unilaterally if the providers engaged in some breach or lack of non-fulfillment without having to turn to jurisdiction or to the courts or arbitration. The rescission was established in Clause 15 of Contract 821. The clause established several grounds or motives for which PEP could rescind the contract. For example, if the work was not carried out in keeping with what was stipulated in the contract, or in the event that the orders issued in writing were not carried out, then a contract could be rescinded. In effect, as the claimants noted, one of the grounds for rescinding the contract was the accumulation of 15 unexecuted work orders, but this was not the only ground. Actually, Drake Mesa, Finley, and Drake Finley undertook to not breach any of the 19 grounds for rescission. In other words, it was suffice to breach a single one of these for the contract to be rescinded. This is exactly what happened. After carrying out the administrative rescission procedure on August 28, 2017, it was decided to rescind Contract 821 for Drake Finley, failed to carry it out, and was covered by several grounds of rescission for the following 5 reasons. The first of these is the failure to carry out Work Order 028-2016, but also there were other orders for verification visits and other requirements, such as for example, calls to meetings and calls to provide documents related to the work order. Second, the very purpose of Contract 821 was unfulfilled when the work order 028-2016 went unfulfilled. Also, there was a violation of Annex DT2 of Contract 821 on not having carried out the drilling work, not doing the verification, and not providing the equipment required to do the work. Nor was information provided about the change in domicile of Drake Finley to be able to receive any notice from PEP. And finally, the program for support of the community and the environment was breached, this under Clause 48 of the contract. Despite the efforts by the claimants, the reality is that it's not been possible to show that this contract was not breached, and in response, the administrative rescission was carried out in a legal manner. Indeed, in the process of administrative rescission, Drake Finley, Drake Mesa, and Finley acknowledged that they violated their obligations under Contract 821, which shows that the claimants, it seems, seek to minimize such breaches. Curiously, despite having breached their obligations to provide support to the community and the environment, the claimants consider that these breaches would somehow be cured on recovering the amounts that were lacking in what has been called the finiquito. This is incorrect. In any event, recovering amounts not yet there should be considered as a penalty and not as a way of curing contractual breaches, particularly when they're related to supporting the community and the environment. As if this were not enough, PEP even notified Drake Finley of these breaches, and it asked them to remedy them, which was completely ignored. Moreover, the claimants' justifications regarding the failure to carry out the work order lack any merit. Throughout this arbitration, the claimants have argued that the work order was a simulation to lead Drake Finley to breach the contract and later justify its rescission. The reality is that nothing shows this. What is shown by the record of this arbitration is that Work Order 028-2016 did exist, and notice of it was made by PEP legally and in keeping with what's established in the contract itself. The claimants also seek to justify the breach of this work order, arguing that Pemex should have had authorization for drilling the well. This is incorrect. 1 month before Work Order 028 was issued, the so-called guidelines for the drilling of wells were issued. As we'll recall, this contract was entered into in February of 2014. That is to say, more than 2 years before the issuance of these guidelines. For this reason, Contract 821 could not provide any way of pulling together the information that PEP needed to obtain authorization of the National Hydrocarbons Commission, and PEP had to draw on the means provided for in the contract itself to gather this information. It did so by issuing the work order. And so Annex DT2 of the contract required that Drake Finley present a detailed program of the drilling work, the drilling equipment, and provide the working materials. None of this was done by Drake Finley under the work order. In addition, it was precisely this information that PEP had to provide to the National Hydrocarbons Commission to secure authorization, and therefore, if Drake Finley did not provide this information, PEP was not in any position to present it so as to be able to obtain the corresponding authorization. Could you speak a little more slowly for the benefit of the stenographers? It's important to highlight, as the claimants have indicated, that the same work order was put to another company, also a foreign capital, Weatherford, which did cooperate with PEP, providing the information it needed to obtain said authorization. Further on, we will very briefly address the trials related to Contract 821. But we would like to emphasize that the acts and omissions by Drake Finley that gave rise to the rescission of Contract 821 were analyzed by the Mexican courts, who already concluded that the rescission determined by PEP was properly justified and was carried out lawfully. Based on this, we find ourselves in the face of a merely contractual dispute which does not fall within the jurisdiction of this tribunal. Once the contract was rescinded, the so-called finiquito was carried out. It was done legally and properly in keeping with Mexican law. In January of 2022, we were able to explain to the tribunal, through our response to the request for provisional measures put forward by the claimants, that in 2017, Pemex attempted to enter into this finiquito with Drake Finley, yet this did not happen until 2021 due to several challenges that were brought against the administrative rescission and Drake Finley's efforts to avoid being notified by Pemex so as to formalize the finiquito. The tribunal will be able to confirm that PEP made at least 4 efforts to notify Drake Finley to attend this meeting to formalize the finiquito. And if that were not enough, PEP attempted to notify Drake Finley at 3 different domiciles. Despite this, the claimants preferred to completely ignore the notices to PEP. And in the face of this situation, on 10 November 2021, PEP had to draw up and formalize the finiquito unilaterally, as allowed by Contract 821. Pemex sought to make one final effort, as the claimants noted, and published 3 notices in the Official Gazette of Mexico and 3 public notices in a national circulation daily. But once again, Drake Finley decided not to attend the meeting, and therefore, in December 21, Drake Finley was notified of the finiquito of the contract. It's clear that PEP exhausted all contractual means to jointly formalize with Drake Finley the finiquito of Contract 821, but this was simply ignored by the claimants. The claimants also allege that PEP did not notify its current attorneys of the calls to enter into the finiquito. Suffice it to note that the attorneys here today are attorneys for Finley, MWS, and Prize, who are authorized solely for the purposes of this arbitration and not for anything related to Contract 821. In very clear terms, as far as we know, neither Drake Finley or the claimants have informed PEP that they're currently represented by Holland and Knight on matters related to Contract 821. This is why PEP is impeded from being able to provide them any type of document. The claimants have not only brought claims related to PEP, they also claim denial of justice by Mexican courts. And this allows me to move on to the next point, which is related to the trials related to Contract 821. For us, it's been very complex to understand the claimant's arguments. And in the face of this situation, the respondent finds that it must explain in great detail the main trials related to this contract. On this basis, the tribunal will be able to conclude that each trial was resolved lawfully with no unwarranted delays. As you can observe, there were two trials related to this contract. First, the what is called Civil Action 200/2016 and its challenges, and in addition, the annulment proceeding 2017 and the challenges that also arose from that proceeding. In April 2016, Drake Finley brought Civil Action 200/2016 against PEP, and in very general terms, it claimed the payment of more than $120 million plus interest, the payment of unrecoverable expenditures or sunk expenditures, and the payment of financial expenses and other items. In other words, at least as from April 2016, the claimants should have known of an alleged violation of NAFTA and of the losses and damages apparently suffered, for it claimed them precisely in the proceeding against PEP. At least 8 legal proceedings stemmed from this civil action, including motions of appeal and amparo proceedings, which were promoted by both, or brought by both Drake Finley and PEP. In April of 2019, the third single-judge court issued what was known as the judgment on the challenge of what we call Second Judgment of Appeal 828/2017, where it absolved Pemex of all of what was sought by Drake Finley in Civil Action 200/2016. Afterwards, there were more actions related to the civil action, but they were focused only on defining whether Drake Finley should pay attorney's fees and costs, nothing more. All of the judgments related to Civil Action 200/2016, including the appeals and the amparo proceedings, concluded that PEP did not breach Contract 821. It's also very important to note that all of these judgments were found legal and constitutional by the competent authorities. Civil Action 200/2016 and the derivative procedures were complex, but this cannot be equated with a violation of NAFTA. Actually, the complexity of this litigation became all the greater since Drake Finley decided to bring a judicial claim against PEP, and it tacitly waived the arbitration clause that had been agreed upon. But in any event, one cannot claim a denial of justice before an investment arbitration panel merely because of not being in agreement with litigation of certain complexity. Indeed, some of the challenges brought by Drake Finley were dismissed because they were initiated in a time-barred fashion and because they waived proceedings that would be declaratory. Moreover, in September 2017, Drake Finley sought to avoid the rescission of Contract 821 before the authority called the Federal Administrative Justice Court through the 2017 annulment proceeding. This proceeding was resolved on October 4th, 2018, i.e., it lasted just over a year. And we want to be very emphatic, noting that Mexico's witness, Mr. Lozano, did not participate in this procedure. The administrative court determined that rescission of the contract was correct and that the notice of the work order was also correct. From the annulment proceeding 2017, well, two procedures stemmed from that, an amparo proceeding, 74/2019, and the motion for review, 1685/2020, brought by Drake Finley. Both proceedings were dismissed on grounds of different vices. But these two proceedings are important in this arbitration because those arguments were raised based on Chapter 11 of the NAFTA. As we've already heard, that is not allowed. Based on a simple comparative exercise, the tribunal can confirm that in the 2017 annulment proceeding, Drake Finley raised practically the same claims as are put forward in this arbitration. The respondent invites the tribunal to analyze this situation in detail. It's described in greater detail at pages 43 to 46 at our counter memorial and pages 22 to 25 of the rejoinder brief. Now, we cannot let the serious accusations made in this arbitration by claimants and their witnesses against Mr. Lozano, which leads us to explain that the supposed September 2018 meeting is not supported by any evidence. The claimants, somewhat desperately, have devoted too much time talking about a supposed meeting in 2018, which at the end of the day is not so important. The claimants argue this alleged meeting involving Mr. Oseguera Kernion, Roberto Quesoyan, and Rodrigo Lozano, in which Mr. Lozano supposedly mentioned that Pemex was intervening in the 2017 annulment proceeding. The supposed conversations between Mr. Oseguera Kernion and Mr. Quesoyan are based on simple hearsay testimony, according to which the claimants seek to argue that a judge, to date we still don't know who it might be, informed someone that the 2017 annulment proceeding would be resolved in favor of Pemex. Indeed, the claimants have not been capable of noting the person who was supposedly designated to meet with this judge. In the claim memorial, it appears that it was Mr. Lozano, but in the reply memorial, it appears quite likely that it was another Pemex official.
It's important to state that the claimants have the burden of proof, and they have only shown the testimony of Mr. Kernion, who has a clear interest in the result of this dispute. The claimants have also submitted a recording of a meeting on Teams in January 2023 between Mr. Quesoyan and Mr. Melsheimer in trying to support claimants' allegations, and this is based also on hearsay. The claimant is not in a position to confirm that the words of Mr. Quesoyan make him a trustworthy person, but we have to consider that Mr. Quesoyan said 17 times that he did not recall the meeting, and if the meeting had taken place, he did not remember that Mr. Lozano was present. I think this is a lack of respect towards Mr. Quesoyan to show a video recording of the Teams meeting, but we invite the tribunal to look at fragments of it. So Mr. Quesoyan disavows the existence of the meeting, and of course these fragments are found at footnotes 64 and 68 of the rejoinder. Now, even if all of this weren't enough, it was shown that in 2018, Mr. Lozano was the legal manager of private law for adjudicatory cases. It is a position in Pemex, and he basically had to deal with issues such as the annulment proceedings of 2017. And in 2017, in May, Mr. Lustano asked for a copy of the rescission of Contract 821. That request had to do with a civil proceeding 200-2016, which is a very different lawsuit from the 2017 annulment proceeding. We also have to recall that there is a clear contradiction in the arguments put by claimants. Initially, they said that the ex parte communications were undue and they violated due process. It is curious to say that claimants have confirmed that Drake Finley representatives and Finley had meetings with judges from the Federal Court of Administrative Justice to talk about the position in connection with the 2017 annulment proceeding. Now, there is no congruence amongst the claims of claimants, and this discussion in connection with the 2018 meeting at La Aceituna is only a red herring for the tribunal, and they're trying to undermine arguments of jurisdiction that Pemex had put in this arbitration. Now, claimants accuse Mr. Lustano and they accuse Pemex in the sense that Mr. Kiosayan allegedly had changed his point of view. Neither Mexico nor Pemex nor Mr. Lustano have coerced Mr. Kiosayan in any way, shape, or form. So Mr. Kiosayan himself said that he had no conversations via WhatsApp with Mr. Lustano in connection with Finley, Drake Finley, and Drake Mesa. What's more, Mr. Kiosayan did not respond to the invitation extended by this tribunal, and there is no evidence that Mr. Kiosayan has any commercial relationship with Pemex or that respondent has any influence on him. On the contrary, it appears that he had a relationship with Mr. Karinian, and at least in the past, he sought to be hired by him. The tribunal is going to be able to confirm that nothing that was alleged in connection with 821 can be considered as a violation of NAFTA. I'm going to very briefly deal with contracts 803 and 804. First, I'm going to talk about 803. The USMCA claims by claimants in connection with 803 have to do with a supposed debt by Pemex because it did not request the number of work orders needed to reach the established amount. Second, and they claim an alleged denial of justice by Mexican courts. And third, an alleged differentiated treatment in connection with a Mexican service providers. As we said at the beginning, 803 was a services contract in order to rework already drilled wells. In spite of the allegations by claimants, 803 was also provided via a tender. We do not think it's necessary to explain again all of the provisions of 803, but we think it's important for the tribunal to take into account Clause 4 that has to do with the amount of the contract. This provision established the amount of $48 million. It also said that PEP had to pay to the contractor only the amount of services that were delivered and accepted. That is to say, PEP had to pay only those works that had been performed. This is relevant because claimants say that PEP had to require the total amount, that is to say, $48 million. But this statement is incorrect. The amount that PEP had to pay was subject to the fact that the PEP work be requested via a work order and that they be performed by BCEL and MWS and then accepted by PEP. So we have to take into account the work performed under this contract. During the term of the contract, 444 work orders were issued, and PEP paid more than $26.5 million for the services rendered. Under the contract, PEP could ask for additional equipment. This is why, in September 2010, BCEL and MWS were asked whether they had the ability to provide 4 additional piece of equipment apart from the 3 that they had at the time, but the answer was not satisfactory. Under 803, Bissell and MWS were penalized because delays in the beginning of their operations and because they exceeded the timelines in the performance of the work in at least 60 occasions. All of this led to the non-issuance of further work orders, and this contract ended naturally. And regrettably, the claims about an alleged early termination, that is incorrect. This is another example of contradictions and ambiguities from claimants. In the statement of claim, it was said that 803 had been terminated in an early manner, but in their reply, claimants changed their argument and they said that 803 was terminated early because Pemex did not execute the full amount. But they also say at the same time that the contract is still in force. It is completely contradictory to say that in the same breath, the contract was terminated early, but it is still in force. 803 was terminated naturally on 30 June 2014, simply because its term expired on 10 February 2015 via the finiquito. This is established by Mr. Asali. Unlike what happened with 821, Bissell and MWF did look at the notice that PEP sent to formalize the finiquito, but both companies also claimed against PEP for the payment of non-recoverable expenses and other items. Now, these things cannot be equated with a denial of justice. From the clear explanation in the memorials by Mexico, the tribunal may recall that the lawsuit of 803 is Civil Proceeding 75-2015, and we had 6 additional proceedings that were brought by PEP and Bissell and MWS. There on the screen, the first one of these lawsuits was the appeal number 35-2015 that was commenced by Bissell and MWS against the dismissal of the civil proceeding. And this appeal was decided in favor of the claimants because it was considered that the dispute was civil in nature. In connection with the second and third cases, one of them has to do with a motion for lack of jurisdiction, and the other one has to do with an appeal number 30-2016, that were started by PEP, Bissell, and MWF. It was considered that the nature of the contracts was administrative. But in the fourth proceeding, which was Appeal 36-2016, it was determined that the controversy was civil in nature, and this was confirmed by Amparo 4-2017, and the motion for review 233-2017. So 75-2015 started in October 2015, and it ended on 1st October 2021 because of lack of procedural motion and because it was then, of course, discontinued. So the complexity of this lawsuit had to do with whether it was a civil or an administrative case. MSW and Bissell were able to bring a number of challenges, a number of courts. For example, the first multi-judge civil court resolved in favor of the nature of the controversy. This was decided to be a civil and not an administrative contract, and this was different from contracts 804, 821. But this is not a contradiction. Simply at that time, there was no legal precept or no case law that confirmed the right nature that was applicable. It was demonstrated that the civil proceeding and each one of the related proceedings were decided in accordance with the law by Mexican authorities without any kind of unjustified delay. And, in point of fact, MWS and Bissell had at their disposal the possibility of bringing any legal mechanism that they saw fit. This would lead this tribunal to conclude that whatever happened in connection with 803 cannot be considered a violation of USMCA. Lastly, we're going to talk about 804.
Muy brevemente. Al igual
Very briefly. Just like in the case of Contract 803, claimants claim the same violations of the USMCA that they allege in connection with 804. Unlike Contracts 803 and 821, Contract 804 was granted directly to MWS and to Bissell in March 2013 because PEP needed services for well drilling, and it needed to do this immediately. We have to recall that at the time, MWS and Bissell already provided services, and they had the necessary response capacity to meet their needs, but the facts demonstrate that this was not the case. The structure of 804 was very similar to that of 803. It had a maximum amount of $55 million. And in this contract, it was clearly established that PEP was not obligated to spending the maximum amount of the budget. Claimants say that Pemex did not perform accordingly because it did not issue any work orders during the first 4 months of the contract. But the lack of work was only the responsibility of Bissell and MWS. The evidence in this arbitration show that MWS and Bissell were the ones that delayed the performance of the work under the contract, and they are the ones responsible for the non-issuance of work orders. In point of fact, PEP tried for more than 4 months for the rigs to be presented, and it requested for more than 4 months that personnel be appointed and that they were given notice of the location of their central offices or the field offices. It conducted a first inspection that showed that there was one piece of equipment that was dismantled and it was being maintained. It also asked for technical information in connection with the equipment, but this was not provided at the date agreed. And then PEP also saw that the equipment was damaged, they were dismantled, and they were lacking some parts. In June 2013, MWS and Bissell received 2 additional work orders, but they didn't even seek to mobilize the equipment until only 1 month after receiving the work orders, and of course this was not within the period of performance. The reality is that under 804, MWS and Bissell did not fulfill a single work order for cases attributable only to them, for causes attributable only to them. Similarly to what happened with 803, 804 was terminated naturally, and now we're going to talk about the claims by claimants in connection with the alleged early termination. And that is, of course, incorrect. In the memorial, it was claimed that 804 was terminated early, but in the reply, claimants modified their arguments to indicate that it was terminated early because Pemex did not use the full amount of the contract, and for some unexplained reason, they think the contract is still in force. 804 was terminated naturally and formally in 2014. MWS and Bissell were part of the finiquito, but they said that they reserved the right to claim for the payment of 40% of the amount of the contract, non-recoverable expenses, and other items. Because of this reason, and because of the claims for denial of justice, we need to briefly talk about the lawsuits in connection with 804. The claims by claimants in connection with this contract are practically the same that claimant put in connection with 803. These lawsuits were decided in a reasonable period of time, considering their complexity. For this contract, there are 2 proceedings that are essentially relevant. Civil Action 120-2015 and the 2019 annulment proceeding, and there were also 5 other proceedings related to them. On 8 December 2015, and MWS and Bissell initiated the civil proceeding 120/2015, and they claimed breaches to 804. And the judge decided to dismiss the case because it was an administrative matter and not a civil matter, so it decided it had no competition. This decision was challenged by MWS and Bissell, but different Mexican tribunals confirmed in the decision for lack of that there was a lack of jurisdiction from the first judge. Then on 5 March 2019, MWF and Bissell started annulment proceeding 2019, where they claimed certain breaches in connection with 804. MWS and Bissell sought the recognition of the payment of $22 million because of the minimum amount of 804, and also the payment of other expenses. There were 3 other incidental motions that were brought as well under annulment proceeding 2019, but this annulment proceeding ended on June 2022 because MWS and Bissell decided to discontinue. I will now give the floor to Mr. Alan Mofilio, who's going to talk about attribution, and he's going to talk about the merits of this arbitration case. Thank you very much. I'm going to speak about attribution, and then I'm going to also talk about the claims related to national treatment, a claim put by claimants. After that, I'm going to conclude our presentation by talking about MST. The actions taken by Pemex and its subsidiaries, including the making of service agreements, are not regulatory activities, and they are not government functions, as the claimant incorrectly alleges. Under Article 1503 of NAFTA and Article 22.3 of USMCA, for an action of a state enterprise to be attributed to the state, that act must be conducted on the basis of an administrative or regulatory authority or other kind of authority. The making of these 3 contracts and the work performed under them and their terminations, rescissions, and finiquitos, and the participation of PEP in the disputes related to these contracts, all these things were not done using a regulatory authority. The purpose of these contracts was for PEP to receive from claimants a number of services. That's all. It appears that claimants consider that the entering into of service agreements related to wells is an activity that is inherently governmental in nature. If this were the case, practically all of the energy companies would be linked to governments, which clearly is not the case. These articles and footnote number 10 of Chapter 22 of USMCA provide a number of examples of what we are to understand by regulatory authority, administrative authority, or any other governmental function. This was explained by the submissions submitted by the United States in this arbitration. Clearly, none of these examples was something that PEP did under the contracts. The claimants also consider that Pemex in particular is an organ of the state under Article 4 of the International Law Commission articles. But it appears that claimants forget that these articles are not applicable to this arbitration. A number of NAFTA awards have examined this situation, and they have reached a conclusion, which is that these articles are not applicable. Let us see a number of examples. In UPS v. Canada, the tribunal indicated that the special rules of chapters 11 and 15 of NAFTA regulated the dispute, and they prevented the Commission articles to be applied. In the case of Mesa v. Canada, the tribunal determined that NAFTA establishes a special regime that distinguishes the parties of the treaty from its companies. This special regime cannot be replaced by the Commission articles. In the remote case and that the tribunal considers that this lex specialis is not applicable, as established in both treaties, and if it considers that the Commission articles are applicable to the actions by PEP, the reality is that these actions would also not be attributable to Mexico. In connection with the argument by claimants related to the status of immunity that Pemex has vis-a-vis the U.S. courts under the U.S. legislation, suffice it to say that Mexico has shown in this arbitration that the rules of attribution under international law are not the same, and they do not have the main purpose that the Foreign Sovereignty Immunities Law of the United States. Pemex was created in 1938, and from then on, it has changed its nature on the basis of the legislation that governs the actions of the company. From its creation, Mexico has been the exclusive property of the Mexican state. It is true that its board of directors includes public officials, but also independent board members. And the director general of Pemex is appointed by the Mexican executive branch of government. But like any other company, the purpose of Pemex and its subsidiaries is to create economic value and to create wealth. Pemex has always had assets and its own legal personality, and started in 2013 after the energy reform. It had more managerial, operational, and technical autonomy. It has a corporate governance, and it is a competitor in the international and in the Mexican energy market. This is why Pemex usually requires a large set of services, and it also provides a large set of services. Let us see some examples as to what some of the tribunals have said in this connection. In UPS v. Canada, the tribunal concluded that the acquisition of services by Canada Post, those were commercial acts, and they were not the subject of responsibility under NAFTA because they were not exercised by a government authority. Another case decided under a different treaty, but that is a good example for this tribunal, is the case of Adel A. Hamadi Al-Tamimi v. Oman. In that case, the tribunal said that in spite of the fact that a state entity had in its board of directors members who were government officials, this did not mean that that entity exercised administrative actions, regulatory actions, or that it has government powers. If the tribunal takes into account the fact that NAFTA and USMCA have a lex specialis on attribution, the conclusions and it takes into account the conclusions that other NAFTA tribunals have reached and the arguments and that the three NAFTA and USMCA parties have reached, it could conclude easily that the events, subject matter of this arbitration related to the three contracts are not attributable to the Mexican state. Let us now look about the claim in connection with national treatment. The facts are very clear. Contract 809 was not in like circumstances vis-a-vis in the other contracts made by the claimants with PEP. Some of the examples we can see on the screen. 809 was born of a direct award process, unlike 803 and 821 that were granted via public tenders. 809 had a purpose, which was to conduct well drilling work, a service that is completely different from that provided under 803. As if this were not enough, unlike the work to be performed under the three contracts made by the claimants, the works under 809 had to be suspended because of force majeure. Because there were floodings and that happened because of a tropical storm that affected one of the wells in which Integradora and Zapata were providing services. This was an atypical situation that did not happen in the other three contracts entered into by claimants. Also, contractors under 809 did perform the work, and they asked for their equipment to be inspected. This did not happen at all in the case of Contract 804. Another clear difference is that 821 was rescinded because of breaches. 809 was not terminated in this manner. It just ended naturally. The reality is that claimants have been unable to show a violation to the national treatment principle. But before dealing with that, let us look at something that is particularly important. We're going to talk about the exceptions for public contracting under NAFTA and USMCA, which give rise to two jurisdictional objections in this arbitration. I was saying at the beginning that we have had to bring at least 14 jurisdictional objections. 2 of them are related to this point in particular. Article 1108 of NAFTA and its counterpart, 1412 in USMCA, provide an exception in connection with the national treatment obligation when it comes to contracts made by a party or by a state company. The tribunal in Mercer v. Canada looked at this situation, and this was confirmed in the awards in the cases of UPS v. Canada, Mesa Power v. Canada, ADF v. the U.S., and Resolute Forest v. Canada, like the claimant correctly stated. We think, members of the tribunal, that claimant is seeking to confuse the tribunal in connection with the nature of these contracts in order to escape this exception that we have on the screen. But the reality is that the facts fit these exceptions. On the one hand, the claimants seek to assert that the contracts made with Pemex are commercial in nature, and they're trying to elude the exceptions. But on the other hand, they say that Pemex's activities of making contracts is a governmental activity, and therefore there is some attribution. The claimants simply cannot assert both things. It is one thing or the other.
Además, el capítulo 13 del TEMEC sobre contratación pública incluye de forma expresa.
Can you hear me now? So let me go back to this point that is very important. Chapter 13 under USMCA on public procurement includes or covers expressly Pemex as one of the companies covered by this chapter. With this in mind, we should recall that Pemex acts are governed by the Pemex law of 2014. Prior to this, it was governed by the Pemex law of 2008 under commercial and administrative standards. Pemex may require a broad scope of range of services, which they also offer, but what should be considered about this specific point is that the procurement process by Pemex and its subsidiaries is of an administrative nature, and now with the new Pemex law of 2014, it is clearer that once the contract has been signed, it becomes of a commercial nature. Bearing this in mind, it should be recalled that several tribunals on investment matters have concluded that they have no jurisdiction in cases on breaches of Article 1102 and also due to procurement activities, which should also be applicable under USMCA, that is Article 14.12.5, which refers to the text of NAFTA. Now, if the tribunal decides to set aside these exceptions, the truth of the matter is that claimants have not proven violation to the national treatment principle. Various arbitral tribunals have indicated that the investor, the claimant investor, has to show three elements. First, that the claimants or their investments have been accorded a specific treatment by the host state. Second, that other investments or investors, that is, the ones in like circumstances, were points of comparison and with the domestic investors or investments, and also similar circumstances, and also the point of comparison are very important, and also that the investors and their investments receive treatment less favorable than according to domestic investors or investment, but this also has to do with nationality. None of this happened in this arbitration, and since this claim has not been proven, it fails before this tribunal. It cannot proceed.
Still 20 pages in your presentation. Mrs. Fleckenstein, how much time do we have left?
They've only gone for 1 hour. They've gone for 1 hour, 45 minutes, so they still have about 15 minutes, 20 minutes left.
Okay, so 15 minutes are still left.
Haremos el mejor esfuerzo para...
We'll do our very best to complete within 15 minutes. Now, going back to this, the claimants have not shown comparable factors among them and Zapata Integradora. They have not indicated that the treatment accorded to claimants was less favorable than the one received by these other two providers of Pemex. And I think that the agreement reached by PEP and Zapata Integradora is justified or grounded on merely contractual factors, and the investment tribunals have identified that for similar circumstances to exist, they need to be replaceable. That is to say, the services or goods provided need to be replaceable, and the truth is that the claimants did not even attempt to analyze these factors. So the conclusion that the tribunal may reach is that on the one hand, they lack jurisdiction to solve issues related to national treatment, and if they decide that they do have jurisdiction, the basic elements have not been proven to show that there was incompliance with 1102 under NAFTA. This leads me to explain Mexico's position as to the minimum standard of treatment. As we see with the jurisdiction in this case, the claimants mixed their three claims based on an alleged violation to the minimum standard of treatment. But as a starting point, the NAFTA and the USMCA only grant or accord the minimum standard of treatment to investments, not investors. And this aspect has not been refuted by claimant. It should also be recalled that in 2001, the Free Trade Commission under NAFTA interpreted that the minimum standard of treatment under 1105 means that under international customary law, which is binding for the tribunals that are constituted under NAFTA, applies, and this has also been reflected under USMCA, but the tribunals under NAFTA have decided in multiple occasions that it is the claimants, the ones that have the burden of proving an alleged violation of a standard under international customary law. And apparently this is accepted by claimants, but claimants have not shown a violation of a standard of this sort. We'd like to be very clear. NAFTA and USMCA have a very limited standard, and they also establish a threshold that is much higher to determine a violation as compared to other treaties, other investment treaties that have provisions on fair and equitable treatment, but of an autonomous nature. This was explained by the U.S. in their opening statements. With this in mind, claimants argue incorrectly that fair and equitable treatment under the minimum standard of treatment protects something that they have called 6 elements: arbitrariness, discrimination, legitimate expectations, transparency, good faith, and something additional that they call abuse or harassment. We do not agree. The 3 parties to the USMCA and NAFTA do not agree with this. First, claimants were not able to show that the conduct of the Mexican judicial authorities reached the level of arbitrariness under international law. The International Court of Justice analyzed this situation in the LC case, and this criterion has been adopted by several NAFTA tribunals. International law defines strictly what the concept of arbitrariness is. You can see some examples on the screen, and an illegal conduct in itself under domestic law does not necessarily imply that it is illegal under international law. This is a standard that is also reflected in some of the cases that we have cited in this arbitration. Second aspect are discrimination. The claimants presented the same argument on discrimination regarding the 3 contracts without any minimum differentiation, but the truth, members of the tribunal, is that discrimination is governed by national treatment and most favored nation principles. Third aspect, the so-called legitimate expectations. This concept is not independent or autonomous under the minimum standard of treatment, and several NAFTA awards support this position. At the most, the so-called legitimate expectations of an investor may only constitute a factor to assess a potential violation of the minimum standard of treatment, but its scope has been significantly limited by NAFTA tribunals. We should also recall this tribunal that Article 14.6 of the USMCA reflects Mexico, the U.S. and Canada's position to provide greater clarity as to what should be understood for by legitimate expectations. As you can tell, this language speaks for itself. Fourth aspect, transparency. The NAFTA parties established explicitly that 1105 does not include an obligation as the claimant intends, and for that reason it is not part of international customary law. Fifth aspect, good faith. Throughout this arbitration, claimants have attempted to argue something meaning that if there is bad faith, that is sufficient to establish a violation of fair and equitable treatment. However, in our opinion, they have not troubled themselves to develop an argument to provide greater clarity. They have cited, as we have, the Waste Management 2 case, but in our opinion, this case clearly does not refer to good faith as an independent obligation under Article 1105 of the NAFTA agreement. Sixth aspect, claimants did not even trouble themselves to clearly and accurately explain those acts that are abusive or in breach by Mexican state, and they have not even explained that these elements are independent from fair and equitable treatment, much less, and this is something important to clarify, claimants have not shown that there is any act that is egregious, grave, that represents a violation of the minimum standard of treatment. Now, notwithstanding that these facts have not been proven, none of the information included in the proceedings that my colleague explained amount to a violation of the minimum standard of treatment. As a starting point, we should bear in mind that the mandate that this tribunal has is not to act as an appellate court or to review decisions issued by the judiciary. The disappointment that the investors may have had, the claimants may have had as a result of this, of the decisions, is not a violation of Article 1105 under NAFTA. And the first case under NAFTA may illustrate this, that is to say, the Asinia case. Now, claimants are attempting to argue that if a case or a proceeding does not come to its end in less than 30 months, that would be denial of justice. If that was the case, and if this approach was incorporated, thousands of cases before the courts in North America should be considered an automatic denial of justice, which clearly would be incorrect. It is simply impressive to hear that, or to see that in their memorial, claimants have included assertions alleging denial of justice by mentioning incorrect application of the law by Mexican courts, but then in their reply they changed their criterion, and now they stated that whatever under 1105 is a breach entails unreasonable or unexplainable delays that under both treaties. Some specificities as to why this is not a denial of justice. Once again, in October 2015, MWS Bissell brought forward the 75-2015 claim, which came to an end in October 2021 due to procedural inactivity. The duration of this lawsuit proceeding was completely normal, bearing in mind its complexity, the number of exceptions presented by the parties, and we should not forget, also given the impact of the COVID-19 pandemic, none of the aspects of these proceedings could amount to denial of justice. Here on the screen you can see some of the examples that, in our opinion, show that we are not here in a case of violation of justice. Now, moving on to Contract 804 and the proceeding, my colleague explained that in connection with Contract 804 there were two relevant proceedings, the civil proceeding 120 and the nullity proceeding of 2019. But once again, none of the actions under both proceedings gives room to an irregularity that may be considered a breach under both treaties as invoked by claimant. Mr. Asali explained very clearly in both reports why there is no violation, and during this week the tribunal will be able to hear him say that in person. Also, the nullity lawsuit 2019 was presented in a very defective way, now leaving aside the pandemic, but also the judiciary, but also the administrative court that decided this claim. We have already explained throughout these 2 hours that in 2016, 2016 claim 2016 was presented by Drake and Finley with claims presented by both parties and challenges, and this was decided, and the challenges were not only by PEP but also by both parties, and this was finally solved by April 2019. And also the 2017 nullity case also was initiated by claimants, which was resolved in less than a year by October 2018. In both proceedings, there were no irregularities in spite of claimants' position. Their complexity does not entail to denial of justice. It is clear that the claims on alleged violations of the minimum level of treatment under NAFTA and USMCA lack any merits. Claimants decided in some cases not to challenge some of the decisions, and in some other cases, these challenges were presented extemporaneously. How is it possible that we are now facing a claim on denial of justice when the claimants themselves presented extemporaneously legal recourses? So this is striking to the tribunal. And we should also recall that claimants also presented some arguments under NAFTA before Mexican courts, which was declared that it was out of place, and that, again, it has an impact on the jurisdiction of the tribunal. Due to time limitations, I am going to conclude Mexico's presentation, and subject to any question that the tribunal may have at this point, we would now be concluding the opening statements of Mexico. And before I conclude, I just want to thank the tribunal for their time and patience, and we deeply hope that this hearing is useful to the tribunal. So for the tribunal to do two things. First, to understand that they lack jurisdiction, and second, that none of the measures claimed by claimants equals a violation of the minimum standard of treatment. Throughout this week, or as long as the tribunal may deem appropriate, we will be available to clear any doubts you may have. Thank you very much. Thank you very much, Mr. Bonfiglio.
The break is almost 10 to 3, so we'll restart at 10 to 4 right here. Thank you.